sir. And then, sir, pleadings will be, majorly it will be in English, except one or two lines in Hindi.
No
it will
problem.
be in English only.
Right.
For uniform, sir, because it is summer, so we have relaxed it that they can only wear a shirt. There will be no band or a coat. And then if you will allow, sir, then audience will be present, though their video and their mic will be muted.
No, they are most welcome. They should see, in fact, the performance of these youngsters. They get encouragement.
Right, sir. And secondly, sir, in case if you want to refer any document in between, any document of defense or prosecution, so you can just ask on the mic, and the volunteers will share the screen. So it will be visible in case if you find any kind of difficulty. So it will be visible on the screen to you.
Right.
So I will be there, sir. Shubham will be there. In case any problem, you just ask us, and we will do the needful.
Fine.
Okay, sir. So Shubham, at 3 the rounds will start.
Yes, sir. At 3 the rounds will start. So shall we call both the participants?
Yeah, please.
All right.
Okay, sir.
Okay. I request both the participants to kindly start their video and unmute themselves. All right. So we would really appreciate if both the counsels can introduce themselves to the honorable court.
But the video should also be there. I should be able to see them.
Yes, sir. The moment
I can only see.
No, sir. The moment they'll speak, they will be on the screen.
Right.
Rabo, if you can please do the testing.
Good afternoon, Your Honor.
Yeah, good afternoon.
With your permission, Your Honor, I would like to begin with the closing argument in the case.
You may.
Much obliged, Your Honor. Your Honor, the case is at a concluding stage, and we'll come to know by the means of closing argument that how these accused have failed to understand the simple concept of no. Your Honors, no in itself is a complete sentence. It does not require any justifications, any explanations, or any clarifications. No means no, no matter who is the other person. She may be your wife, she may be your girlfriend, or she may be your enemy. Your Honors, but when she says no, you need to stop. In the instant case, Your Honor, when the barbaric crime of rape was committed on 10th of September 2019, and both the victims begged in front of these accused to leave them. They raped them brutally. Also, Your Honor, they attacked them with a rod and acid.
2 were raped?
Yes, Your Honor. Both of them were raped.
Right.
With your permission, Your Honor, I would like to brief the court with the facts of this case.
Correct. Do that.
Much obliged, Your Honor. Your Honor, a PCR call was received on 10th of September 2019 at 4:59, which could be accessed at page 33 of the LCR. The police reached the crime spot and got to know that the bodies were taken to the hospital. Your Honors, on reaching the hospital, the statement of Ms. Tanu Sharma, the complainant in the case, was recorded, and such rukka was forwarded to the police station for registration of the FIR. The FIR can be accessed at page 25 of the LCR, Your Honor. Your Honor, on such rukka, an FIR was registered under section 376, 326A, 307, 34, and 120B of IPC. Your Honors, page number 34, which shows the first recovery memo where the police has seized the iron rod. Also, Your Honor, when victim number 1 was taken to the hospital, she was badly injured, and a dying declaration was recorded, which is present at page 57 in the presence of a police officer and a medical practitioner. Your Honors, also the medical legal certificate or a medical legal record of victim number 2, that is Suman, for sexual offenses is present at page number 56 of
Just a second, page 56, right?
Yes, Your Honor.
Okay.
Don't
rush, just assist me. Just relax and assist me nicely. You don't have to rush.
Okay.
Be relaxed,
Okay.
you are doing very good. 56.
Thank you, Your Honor. Your 56 is the report of the medical legal. Yes, Your Honor. MLC
Correct.
of victim number 2.
Correct.
Now, based on such statement, based on the statement of the dying declaration and also the statement of victim number 2, Your Honor, when the police came to know that Mr. Rajveer Vats and Shreyansh Rai were involved in such crime, they went and arrested Mr. Rajveer Vats. The arrest memo is present at page number 61 of the LCR, Your Honor. Your Honor, after the arrest, a disclosure statement was given by the accused number 1, which is present at page 64. And based on the findings of the disclosure statement, a pointing out memo was made, which is present at page number 65, Your Honor. Your Honor, a silver color Amaze car, which was used in the crime, and also a acid bottle was recovered based on the disclosure statement of accused number 1. Now, both the accused, since they were involved in sexual violence, Your Honors, so there's a prescription by the Supreme Court to undergo a medical legal, they have to undergo for a MLC. And hence, accused number 1 was sent for an MLC. The MLC is present at page 69 for Mr. Rajveer Vats and page 89 for Mr. Shreyansh Rai. Your Honor, based on the disclosure statement of accused number 2, which is present at page 83, after he was arrested, he gave a disclosure statement to the police authorities. The police authorities also came to know that there is a third victim of the case. The third victim, Your Honor, is Mr. Shubham Kotak, and I'll gradually brief you that how he is involved in the case. Based on such disclosure statement, a body was recovered of Mr. Shubham Kotak from the farmhouse of Mr. Shivam Sharma, who is accused number 3 in this case. The photo of the body is present at page 84 and 85, Your Honors. He was brutally murdered with a shotgun. Your Honor, an inquest report was prepared by the magistrate, which is present at page number 100, and the body was sent for a post-mortem. Meanwhile, Your Honor,
post-mortem is at what page?
Page 108 for victim number 1.
Just a second. Okay.
108 for victim number 1.
Right.
And 116 for victim number 3.
Okay.
The victim number 2 is still alive, Your Honor.
Correct. He's in.
Your Honor, the death certificates are at page number 105 for 115 for victim number 1 and 123 for victim number 3.
Fine.
After the scene, Your Honor, a seizure memo was prepared because the body was found from the farmhouse of accused number 3, and blood-soaked clothes of accused 1 and accused number 2 was also found.
Fine.
Also, Your Honors, Mr. Shivam Sharma was arrested meanwhile. And based on his disclosure statement, Your Honors, the arrest memo is at page 124. And based on his disclosure statement, a Mossberg 512 gauge shotgun was recovered, which is present at page 130. Also, the seizure memo can be accessed at page 131 of the LCR. Your Honor, request for recording of the statement was of the victim under 164 was sent to the magistrate.
Just a second.
Yes, sir.
Who was the witness to the seizure memo?
The witness to the seizure memo.
Were there police officials or any public person was also involved?
Your Honor, there was one public person also involved, who is Mr. Harshit Malhotra. His statement is there on record. He also appeared as a prosecution witness. And
he supported the prosecution?
Yes, yes, Your Honor.
Right, right.
Your Honor, then a request for recording of the statement of victim number 2, who was alive, was sent to the magistrate to record her statement under 164.
Under 164, right.
Yes, Your Honor. Such statement is present at page 137.
Right.
Your Honor, also, a permission for TIP was requested from the magistrate, though accused number 1 and accused number 2 refused for the TIP. And the report is present for accused number 1 at 143 and for accused number 2 at 147. Also, meanwhile, accused number 4 and accused number 5, who have assisted accused number 1, 2, and 3 in the said crime, were also arrested, and the arrest memo is present at page 149 for accused number 4 and at page 154 for accused number 5. Your Honor, the police began with the investigation, and the first thing what they found was a CCTV drive from the Resident Welfare Association's office of the crime spot 1, which can be accessed at page 165, and a CCTV analysis report at page 170. Moreover, the gun was sent for ballistic examination, and such report is present at page 176 of the LCR. Also, Your Honor, the fingerprint analysis report of the steel rod, which was recovered from the crime spot 1, is present at page 182, while the fingerprint analysis report for the Mossberg 500 shotgun is present at page 186 of the LCR. Your Honor, the FSL was also conducted on the clothes which was seized, and there are various articles. The FSL report is present at page 195 of the LCR. Also, a request for call detail report was sent by the police authorities, and a request for location was also asked in the same. Both the reports are present at page 200 for accused number 1 and 211 for accused number 2, Your Honor. Your Honor, also, the district magistrate was sent a request letter to ask about the whereabouts of the gun, because Your Honor, the arms and ammunition falls under the district magistrate. So he replied from there, and the letter is also attached at page 157.
No license.
No license, Your Honor. Moreover, the gun is banned in India. It cannot be, like, shotguns are banned in India, Your Honor.
Section 27 and 25.
Indeed, Your Honor. Indeed, right. Your Honor. Your Honor, hence, based on the same, the framing of charges was done, and the order of the framing of charges is part of the LCR at page 287,
nice.
Where charges were framed for accused 1 under 302, 307, 326A for acid attack, 376 for rape, and 120B. While for accused number 1 and 2, they have same charges, Your Honor. For accused number 3, we have 302, 364, 120B, and 25 of the Arms Act. And 4 and 5 were charged under 120B and 25 of the Arms Act. Though, Your Honor, after the fingerprint expert's report came, the accused number 4 and 5 also had their fingerprints on the gun. And based on the same, an application under 216 was moved, and hence the charges were altered, and 302 was also, like, the accused number 4 and 5 were also charged under 302. Again, the order of the said can be found at page 345 of the LCR, Your Honor. Your Honor, these were the facts of these cases. We began with the prosecution witnesses. Your Honor, if you permit,
Can I stop you here? Just one
yes,
query.
Yes.
On
yes,
what basis charge of 120B, a criminal conspiracy, was framed?
Your Honor,
what was the material for? Yeah.
Your Honor, the material for bringing the offense of charge of 120B in this case was that all the 5 accused are friends, and they have done this crime by conspiring against the victim number 1, and that can be accessed. Like, Your Honor, I'll deal in detail while dealing with the witnesses that how the offenses are made out.
No, I'm not. I appreciate it. For the purpose of framing of charge, what material you had or the prosecution had to claim before the court that a criminal conspiracy was hatched? Because criminal conspiracy is a state of mind. Some circumstances prior to the commission of the offense have to be shown that these were the chain of connection between the accused, and they were conspiring since long to do that. 120B cannot come out just out of the blues. You can't impose 120B. It's a very serious offense, because 120B, the offense of one is considered to be the offense by all. I'm sitting in my office and I conspire to get someone murdered. The actual person who has murdered will be convicted for the same offense and the same sentence. I will be for that same sentence and same offense by virtue of 120B. So 120B, criminal conspiracy, ties everyone together. So that is important, that I have to see that 120B, how it was made out, because I read everything. For me, 120B, yes, I'm open to all the arguments, but as of now, 120B is something dicey here. That's it.
Your
So
Honor,
just
Your Honor,
keep this in mind.
There are two basic requirements for 120B. First is that there should be an agreement.
Correct.
And second, that there should be an agreement for an illegal act, or
Correct.
an act which is illegal in itself, but is done by illegal means. Yeah.
Accepted.
So now
where is that agreement? Prima facie, where is that agreement shown? For the purpose of framing a charge, we'll come to the trial later. Where is that agreement? From the charge sheet, you can show that this was the agreement. These are the ingredients which show agreement amongst the parties, among the accused.
Your Honor, the agreement can be seen by the virtue of disclosure statement. Now, the disclosure statement clearly brings to light that there was a tacit agreement between the accused to rape the victim 1 and to murder the victim 3, that is Shubham Kotak, because the accused number 3, which is Shivam Sharma, the husband of victim number 1, Your Honor, he was very clear that there is some kind of relation between victim 1 and victim 3, and because of the same, he has this plan to murder both of them.
This is all on the basis of disclosure?
Not only on disclosure, Your Honor. Allow me to come to the witnesses one by one, and I may brief and much obliged, Your Honor. Your Honor, the prosecution witness 1, who is Ms. Suman Singh, the one.
I'll just open the testimony. Just give me a second, please.
Yes,
I'm so sorry. Just give me, because I'm a bit clumsy with this tech. I'm not as conversant as you youngsters are.
You can refer to the statement under 164 at page 139, Your Honor.
I got it. Just give me a minute. I'm just opening it. Right. Which page you said? PW1?
Your Honor, the statement of 164 is at page 138, while the statement before this court is at page 292.
292. Just a second.
Yes, Your Honor.
This hand pagination? Hand pagination,
no,
right?
Your Honor. The LCR, like not the hand pagination.
Right. 292, which is in the written and circled, right? Page number is circled.
No,
Am I
Your
right?
Honor.
No.
No, Your Honor. That is page 292
see,
of
page,
the LCR.
Page 280, just for my reference, just see page 280. It is conviction slip. Am I right?
Yes, Your Honor.
Right. So I'm
page
280.
Page 280 is the conviction slip
of Kedar. What his name is?
Mr. Kedar Mishra.
Correct. So this is 280, and after that I have this. After that I don't have numbers. Just check it.
Your Honor, this is a compiled version of LCR, and I'll tell you. Just scroll down a bit because there are some miscellaneous orders.
Right.
And after 5 to 7 pages, you will find the statement, Your Honor. That is page 292 of the whole document, of the PDF document, Your Honor. Statement of Suman Singh, prosecution witness 1, in case number 1662419.
Justice. Maybe you are right. Right.
292.
Just a moment. I'll be there. Okay. Yeah, continue.
So, Your Honor, this is the statement of prosecution witness 1. We may read it conjointly with the statement under 164 also. It is similar, both the statements are similar and in corroboration with each other.
She admitted having given her 164? She got it exhibited?
Yes, Your Honor.
Right.
Page, for that you may access at page 139.
Right.
It was marked by the judges at point A.
Right. And the magistrate was also examined to prove it?
No, Your Honor. Magistrate was not examined.
Then how 164 was proved? Carry on.
Your Honor, magistrate was not examined because there was a order of High Court needed for the same, and the prosecution did not have the order of order under 16 order from the High Court.
No, the magistrate could have been summoned for statement in the court as a witness.
The magistrate was summoned, Your Honor, and if you may have a look at the list of prosecution witnesses which was submitted.
Correct. So, but he did not turn up, or what happened?
He turned up, Your Honor, but the judge did not allow him to step into the witness box.
But the girl has admitted the statement.
The girl has admitted.
Your Honor. Right,
yes,
right.
Yes, Your Honor. The girl admitted.
Fine.
So, Your Honor, both the statements are in corroboration with each other. And if you have a look at the third line of the statement present at 292, once Tanu left the home, I and Manu were alone at home. And after 10 minutes, her doorbell rang.
Correct.
She went and I was sitting in the first floor and waiting. All of a sudden, I heard screaming of Manu and I went downstairs to see what has happened.
Correct.
I saw Shreyansh and Rajveer.
Right.
They were beating Manu and she was screaming and shouting.
Right.
I went to help her. Then Rajveer leave her and caught me and I was trying to escape.
Right.
Then they hit hard on my head and I fell on the floor. And I'm unable to wake up and lying on the floor and I couldn't help her. She's screaming as they were beating and they raped her and they also shouting that आज दिन अच्छा है एक के बदले दो मिल गई. Your Honor, kindly note this point that एक के बदले दो मिल गई because I'll be using it in corroboration with the 164 statement.
Fine.
Then they left her lying on the floor. They were biting all over her body. This should also be noted, Your Honors, because there were bite marks present on the body of the victims. And if we'll have an access to the post-mortem as well as the MLC, the same could be proved, Your Honor. Then they came towards me and I was crying and telling not to rape me, but they raped me as well. And I was screaming to stop, but they did not stop. And when they were satisfied, Rajveer gone and comes with a rod. And with that rod, he hits Manu hard on her head. Your Honor, also, she started bleeding and I asked them to stop, but they did not stop. Both of them came with the bottle in their hand, filled with some liquid, and poured the liquid on the body of Miss Manu. And she started screaming, shouting, and her whole body was burning. And while doing that, they were saying that हमारे दोस्त को धोखा देगी. And after that, they came to me and poured it on me also. and saying that I will tell anyone, they'll do the same what they did to Manu. Your Honors, if you may refer to the statement under 164 at page 139, which is marked at point A. Page 139 of the LCR, Your Honor. The statement is page 138 of the LCR. And if you want to, the manual pagination is 136.
Right.
Your Honors, the statement is in corroboration with the 164 statement. Her doorbell rings and she went downstairs to open the door. After 10 minutes, I heard Manu screaming and shouting. So I ran downstairs, where I was shocked to see Rajveer and Suryansh, who were Shivam's friends. They were beating Manu and she was resisting. Seeing that, I went for her help. ... Your Honors, all the intricacies of both the statements are matching, and
which
hence
is
they are in
page 136, right?
Yes, Your Honor.
But my 130 starts with Manu and I were best friends since childhood.
Yes, Your Honor. Yes, Your Honor. I am referring to the 7th line of the same paragraph.
Okay, 1, 2, 3, 4, 5, 6, 7. I went to the house at 1 o'clock. We were sitting in a room of first floor. Later, Tanu left for her coaching. That's right?
Yes, Your Honor.
Right.
At 2. Then sitting in the room of the first floor, later Tanu left for coaching. Then Manu told me while we were chatting about our senior in the college, he used to be our senior in college. She told me that she met him in the mall nearby and were good friends now. So meanwhile they were discussing this about the senior. After 10 minutes, Your Honor, if you could come to...
After 10 minutes, I heard Manu screaming and shouting.
Yeah, so I ran downstairs, where I was shocked to see Rajveer and Suryansh, who were Shivam's friends. They were beating Manu and she was resisting. Seeing that, I went to her help and tried to stop them too. When Rajveer left Manu and caught me, Rajveer was beating me continuously on my head, which I resisted. Then Suryansh came and I bite him on his hand. So the bite marks, Your Honors, about which were talked, both are collaborating with each other. They got angry and threw me in the corner of the floor. They hit me so hard that I could not stand, but I was crying for help, but no one came. Until then, Manu was lying on the floor. They went to him, removed her pajamas and raped her. She was crying for help, but they did not stop. They molested her brutally, biting all over her body. They were talking among themselves. आज दिन अच्छा है, एक के बदले दो मिल गई. Then they came
to me.
I was begging in front of them not to rape me, but they did not stop. Also, Your Honor, if you can have a look at the 6th last line of the statement, the same word that हमारे दोस्त को धोखा दिया. After that, they came to me and poured the liquid on my hand.
Right.
It was burning like hell and I was screaming. They hit me hard on my abdomen, vagina, multiple times. While I was lying on the floor, they told me that. Hence, Your Honors, both the statements of the prosecution witness 1, who is Ms. Suman Sharma, the victim number 3, are in corroboration with each other, whether it is in front of the magistrate or the statement given to the court, Your Honor. And at times, Your Honor, this court has relied on the sole testimony of a prosecutrix under 164 to convict the people. However, there are ample evidences apart from the prosecutrix statement as well.
Correct.
Your Honor's prosecution witness 2, Ms. Tanu Sharma, who is the sister of the deceased.
Page continuation.
Page 25, Your Honor. That is the Rukka. So I request you to have a look at the Rukka.
Page, this running page 25.
Your Honor, page 294 is our statement, while the Rukka is at page 25.
Okay, go ahead.
So page 294.
You want me to read page 294 or the Rukka?
Page 294, Your Honor. Because I'll use Rukka for corroboration, Your Honor.
Right.
Tell me about yourself. I'm a sister
Rukka was at the instance of?
Pardon, Your Honor?
Rukka was at the instance of?
Ms. Tanu Sharma, Your Honor.
Tanu Sharma, right. Fine.
Yeah. tell me about the instance. On 10th of September 2019, I saw two people running out of my house. Two people running out of my house, Your Honor. Right. I went in the house and I saw my sister lying on the floor and she was bleeding and her body was burned. And nearby her, I saw her friend Suman. She was also lying there and she was little unconscious. She was trying to say something, but I can't understand what she was wanted to say. I'm helpless and shocked and didn't understand what to do. So I ran out of my house and cried for help. And one of the cars stopped. The person helped me to take them to hospital. Whether you gave any statement to the police? Yes. How did the police came to you? I called the police and when the man stops the car. So while she was stopping the other person, she was also calling the police. Your Honor.
Correct.
However, there was no cross as such, Your Honor. Maybe the defense counsel can throw light over the cross which was conducted. And then if we may have a look at the Rukka which was present. So that is a detailed complaint, Your Honor.
So you mean to say that Rukka is corroborated by her evidence, by her statement in the court?
By her statement, Your Honor.
And she proved the Rukka?
Yes, Your Honor. Right. And the Rukka is also exhibited as exhibit PW2/A.
Right. Right. Carry on.
Your Honor, also the person who registered the FIR, the SHO of Karol Bagh Station. Yeah. Okay. So Karol Bagh Station, he was there, and the FIR is also exhibited as PW3A at page 28, Your Honor.
Right. Right.
There are also statements of the father and the mother of the deceased, Your Honor, which is present at page 297 and page 298, which show some stern relationship between the victim 1 and the accused number 3.
Strained.
Yes.
Strained
relationship.
Right. Okay.
Yes, Your Honor. Now coming to the statement of prosecution witness 6, Mr. Rupesh Singh, Your Honor. And for that, I would request you to...
Page?
I would request you to please have a look at page 70, which is the medical legal report, Your Honor.
Right. Just a second. It is there with the charge sheet also, no?
Yes, Your Honor. Page 66 of the manual pagination.
Right. Page 66.
This is the detailed medical legal report, Your Honor, where the consent of the accused was taken for such record.
Page 60?
Page 66.
This is immediately after the photographs?
No, Your Honor. After the photograph is the request for
yes,
such an
exhibit PW6/1. Medical legal examination of accused of sexual violence. Correct. Yeah,
yes,
tell me.
The next page, that is page 67, point C.
Point C.
Injuries present on the body of the accused. The hand was burned. There were bite marks on the body of the accused, which shows signs of struggle, Your Honor.
Yeah, injury is present on the body of the accused. The hand was burnt. There were bite marks on the body of the accused. Fine.
Moreover, Your Honors.
Yeah.
Then, Your Honors, at page 73, the anterior view of the body.
Just a second. 73. Can somebody
of the man
can somebody play this on the screen also along with us?
No. Yes, yes, sir. I request you. I request the registry to kindly open
these
page
pages
72.
so I can see it parallelly, because then I have to see on my other screen and then refer to page 73.
Yes, Your Honor.
Okay. Yes,
if the registry is there.
No problem.
Can you start screen share?
They must have heard.
Okay. So, Your Honor, page 73. If you may have a look.
Abrasion.
There are bite marks on the shoulder. Bite marks on the left hand.
That is not 73.
Page 73 of the PDF document, Your Honor. I think there's much confusion because of this.
No,
page
no,
yes.
Yeah. Page,
yes.
See, this page you are referring?
I'm referring, see, Your Honor, this is page 73 of the whole document.
No, it is there on the screen.
The charge.
Which one you want?
This page only, Your Honor.
Right. Yeah, tell me, this is page 70.
Yes, Your Honor, but of the PDF document, it is page 73.
Maybe. Right. You want to refer to this. Now tell me, please. What do you want to say?
Your Honor, bite marks on the shoulder.
Correct.
Bite marks on the left hand.
Right.
Burn marks on the hand, palm.
Correct. Right.
Abrasions near the leg, lower portion of the leg.
Yeah. You show me. Yeah,
that's
right. AB.
Yes, Your Honor. If we can have a look at the next page, which is the posterior view of the body.
Oh, yeah.
Swelling marks on the back thigh.
Just show me. A little. Just slide it a little up, please. Yeah, that's right.
Swelling.
Fine.
Yes,
there's swelling marks. Okay.
Then next, if you can come to page 73 of the pagination, of the manual pagination.
73.
The photograph of the private parts of the accused.
Right.
Abrasion on the scrotum area.
Correct.
Swelling on the scrotum area.
No, so what do you want to imply by this? That I am understanding.
Your Honor, we want to imply that there are marks of struggle on the body of the accused.
No, that is there. But on the private part, what do you want to say? You mean to say that sexual intercourse took place?
Yes, Your Honor.
No, this one, page 73, is only for that purpose, no?
Yes, Your Honor.
This cannot show struggle.
No,
this can be only a sexual intercourse had taken place.
Page 73 shows that there was sexual intercourse, while the anterior and the posterior view shows that there was struggle.
That I got
because of the bite marks.
Yes, now page 73, how does it show sexual intercourse? Only by abrasion?
Your Honor, not only by abrasion, but also like I would refer to.
Was the swab taken? Swab?
Yes, Your Honor.
Semen,
the swab was taken. Yes.
Semen was found? Semen was found in the vagina?
Yes, Your Honor.
And DNA was undertaken?
The DNA report was undertaken, Your Honor. If you may refer to page number 7, page 76 of the.
Yeah, you can request the registrar, please. Page 76. 75, 76, right.
The opinion report.
Just slide it a bit up, please. That's perfect. That's perfect. Taking into consideration the history of case, the data and clinical examination and the report of the FSL and other investigations, the possibility of performance of sexual intercourse of vaginal, anal, urethral, oral and male by male sex organ of Rajvi births under cannot be ruled out. See, this is okay. The presence of bite marks on the body of the accused only show marks of struggle. Right. See.
Also, Your Honor, about the semen which you are mentioning.
Correct.
So that is present in the vaginal swab of the victim. Yeah.
That is there. That means the semen was there. Now the semen matches with the accused. That matching report, DNA report or forensic report is there, matching the semen. That the semen on the vagina was of the same person.
That is in the MLC of the victim number 2, Your Honor. I'll come to it.
So fine. See, you have to show me. You have to show me the matching of the semen on the vagina with the matching of the semen swab taken from the private part of the accused.
Yes, Your
Honor. To show that same accused had committed the rape.
So the swabs were collected, and the report kindly refer to the report. The report mentions about it that swabs were collected from the body of.
Correct. Collected. Where is the result of that?
Now the result is in the opinion report of the victim number 2.
Where it is?
When the
which page?
Page 56 of the.
56, registrar, please. Page 56. Can we come to page 56, please? That's 53, 54, 56. Yeah. This is what you are referring to? No.
This is the MLC of the victim number 2, Your Honor.
Are you having a look at the page? I doubt this is the MLC.
They have referred to page 56 of the pagination. Now this is the
finding of the support in the opinion, taking into account the history, clinical examination, finding of Suman Singh bearing identification mark described a day before the incident sexual offense. Report, I am of the opinion that 2 accused have committed rape victim as there is presence of semen of accused Rajveer on the, yes, that is right. There is a presence of semen of accused 2 in the vagina of victim, presence of male pubic hair in the urethra of victim. The injuries in the private area of the victim clearly showed that there was forceful sexual intercourse by the accused, right? Fine.
So
good.
Both the reports
you
are
mean to say you have been able to connect the accused and the crime?
Indeed, Your Honor, indeed. Both the accused. If you may have a look at the medical legal report of Mr. Shreyansh Rai, which is present at page 70 of the man. Please refer to page 70 of the LCR, not the charge sheet.
LCR, please. No. This is the diagram.
Page 70 of the LCR.
Low court record.
Yes, and also for the anterior and posterior view, you may refer to page 93, and for the opinion report, page 99.
You please help
page 93. Yeah, page 93 of the LCR.
I think they are still struggling with the charge sheets.
Yes, Your Honor.
You help them, please.
Shifting to online is not so easy, Your Honor.
I understand. They must be. Just help them. Because they are on the.
Yes. This one only. So this is the anterior and posterior view of accused number 2, Mr. Shreyansh Rai, Your Honor.
Right. This you had shown me right now.
No. That was for accused 1.
Okay. Fine. I got it. Right.
So there's
abrasion on the shoulder.
Bite
marks, correct.
Yeah.
Right.
Also abrasion on the lower part of the leg. Correct. Then if you may scroll down to page 93.
93, yeah.
That is the private parts. And the opinion report is at page 99 of the LCR. So both the semens were collected from the body of both the accused, Your Honor, and both of them matched. Detailed report I have already shown to this court.
Fine.
The sexual intercourse possibility, that is of vaginal and urethral intercourse, cannot be excluded. Also, the presence of scratch marks on the body of the accused clearly show the struggle done by the victim. So, Your Honors, by both these reports, it is very clear, by both the reports of the accused MLCs, it is clear that first thing, the rape was committed, and the marks of struggle also proves the same.
Correct.
Now, referring to the statement of Ms. Tanishka Jain, who is prosecution witness 8, the statement is at page 301 of the LCR.
301 of the LCR, please. This is the one?
Yes, Your Honor.
This is recorded in the court, or this is 164?
The recording in the court, Your Honor.
Right. Yeah, tell me what you want to refer.
What have you done in this case? I have done the MLC examination. The victim came to the hospital and gave the report to the FSL department. What was your opinion in the case? According to the findings, there was semen found in the vaginal cavity of Ms. Suman Singh, and the semen was of both the accused people. Also, there was found hair in the urethra of the accused.
No, it will be victim number 2.
Yeah, victim number 2.
Yeah, that's a typo error. Yeah.
Do you try to verify those things? Yes, I did. What sort of injuries were there on the victim's body? The victims had a tenons on the skull. There were bite marks on the lips and quite a more injury.
That was with tendon on the skull. Right.
Yeah, tendon on the skull, Your Honor. What was your opinion? She was being raped and by the 2 accused people. Exhibit PW7A at page 52 of the manual pagination, and it is page 55 of the LCR.
Correct. 55.
That is the last page, Your Honor. I'll turn on to
55.
So page 56 is the final opinion report, Your Honor. Scroll down a bit, which clearly shows the presence of page 56. Scroll down to the next page.
53. This is 53.
Yeah. Yes, Your Honor. This page only.
Finding of the in support of the opinion taken to okay.
The report we just saw, Your Honor.
Correct.
Also, page 46 of the LCR talks about the injuries on the body of victim number 2.
Fine.
Pardon, Your Honor. Page 46.
Page 46. Page 46, please. I think there's some communication there.
Page 46, please, of the LCR.
Page 46. Which one? This one you are saying?
Yes, Your Honor.
The pattern of injuries.
Yes, Your
Right.
Honor.
You read it, no problem. You read it.
So, scalp examination for areas of tenderness if haired pulled out or dragged by hair.
Correct.
Yes, the scalp has area of tenderness near occipital belly.
Yes, occipital.
So
correct.
the victim,
That means she was hit.
Yeah, the victim already testified before this court, Your Honor, that they hold her through her hair and threw her in the corner.
Correct.
So the same is corroborated.
Correct.
The jawbone is fractured. That is a minor fracture in the jawbone.
Little down, please. This one on the screen. Jawbone fractured one. Yes. A little bit more. Correct. That's perfect.
Lips have teeth bite marks. The lips were having teeth bite marks.
Correct. Breast has abrasion.
Had an abrasion of 2 centimeters.
2 centimeters into 1
point.
Yeah, so that means
lower limb buttocks, abrasion of 4 into 6 centimeters. Abdomen
down,
is
please.
badly injured.
Correct. Just little down. Yeah, abrasion. Abdomen is badly injured. The belly has burn injuries of acid. Oh my God. Highly corrosive in nature. Correct. Right. Okay.
The anterior view of the body is at page 47. Just scroll down to the next page.
Of the victim, right?
Yes, Your Honor. Now,
bite marks,
how badly,
fracture.
Yes, Your Honor. How badly she is injured in
so according to you, it was brutal.
Indeed, Your Honor, it was brutal.
Right.
Now, what can be more brutal than this?
Right. Fine.
Then
slide
the
a bit low.
View.
Go down, please. Any injuries on the legs? No. Right. Carry on.
The next page, Your Honor, the posterior view. Just scroll down. Yeah.
This is tenderness.
So the tenderness, yeah,
correct.
on the occipital region and the abrasions on the lower buttocks.
Abrasion. Okay. Correct.
Then you can come to next page. Please come to the next page.
Yeah.
The examination of the
external genitalia. Yeah. Got it.
So
ruptured with abrasion. Uterus is ruptured with abrasion. Labia majora, bite marks on the lower parts. Oh my God. Bite marks there also?
Yes, Your Honor.
Oh, that's okay. Hymen
is broken.
Then that has to be. That doesn't make a difference. These days hymens are always broken. So that nothing turns out on that. Next, please go down.
Page 57. Page 57.
Yeah.
That is just a pictorial representation of the.
Yeah. Show me 57, please. This is 54 dying declaration. 57
sorry,
you want, no?
Sorry, 51.
51. Yeah. What is that? 51 is?
That is the photograph of the private parts of the victim, Your Honor.
Okay.
Not the photograph, but rather a pictorial representation.
Pictorial, correct. No, this is. I think you are not on same.
I'm so sorry, Your Honor. Just scroll down a bit. Scroll up a bit. come to page 47 of the manual pagination. 47 of the manual pagination. Just scroll up.
Scroll down now. Yeah, this one. Okay.
Yeah. So bite marks and abrasions.
Okay, I got it. Yeah, it's clear from the report itself. Fine.
And the clothes were also seized, Your Honor, and sent for FSL. And there is presence of semen on the same.
Right. And that also matches with the accused?
It matches with the accused. I'll refer to it when I refer to the FSL, Your Honor.
Fine.
So, after the opinion report, Your Honor, it's very clear that the accused number 1 and accused number 2 were involved in a sexual intercourse with the victim number 2. And hence, talking about 376, that is already fulfilled, Your Honor.
Correct.
And 326A, because they attacked her with acid. So that is also fulfilled. The FSL report has detected acid from the clothes of the victim and the body of the victim, Your Honor.
Correct.
And there's a judgment also of Mahadev versus State of Maharashtra, in which it was laid down that conviction on the sole basis where semen was present in the vagina of the victim. Based on that, a conviction was done, Your Honor. Now,
Justice Gyan Sudha Mishra?
That is
which year?
Just a second. I think Justice Khalifullah, Your Honor.
Right. Carry on.
2013.
Right.
Now, referring to the prosecution witness 7th statement, Mr. Mukul Agnihotri, who conducted the post-mortem in this case, the post-mortem report is present at page 109, Your Honor, of the LCR.
109, please.
Marked as exhibit PW71.
71. Yeah. Okay. Body is received. Then, yeah. What do you want to infer from this?
Page 111, Your Honor, talks about severe hemorrhage and blood clotting. Page 111 of the LCR.
Severe hemorrhage and blood clotting, right?
And while point 10 talks about spinal cord crack and clotting in brain.
Fine.
So, if you remember, Your Honor, while discussing about the statement of victim number 1, she clearly told and deposed before this court that victim number 1 was beaten badly by a steel rod. The rod is also sent for forensics. So this severe hemorrhage and blood clotting is the result of that beating, Your Honor.
Correct.
And that can be clearly inferred from the.
So you say that it corroborates the injuries.
Yes, Your Honor.
Correct.
It corroborates the injuries, and moreover, there's bleeding from large intestine. And if you may refer to 114, which is the opinion report, the cause of death is excessive blood loss due to hemorrhage in skull and because of internal injuries in the spinal cord and private parts. The body is burnt with acid. The time since death is 3 to 4 hours.
Correct.
Also, at page 113, just scroll up a bit, scroll up. There were abrasions over the bony prominences, left shoulder, knee, and both mandibles. The left clavicle was fractured, and there were bruises in the arms, legs, probably caused due to beating.
Correct.
There was excessive blood loss due to several hemorrhages in the skull, 1 injuries on face, hand, shoulder, neck, and navel region. The weapon may be a blunt, heavy rod.
Correct.
Please note down this point here. The weapon may be a blunt, heavy rod. Also, if we may come to the post-mortem report of victim number 3 at page 117.
117, please.
Marked as exhibit PW7/2.
Correct.
Your Honor, Now page 119 talks about internal fracture alongside severe medullary hemorrhage and severe damage caused to occipital lobe alongside moderate damage to the temporal lobes and pons.
Temporal, correct.
Yeah. And the opinion report at page 121, if you may scroll down a bit.
Opinion, cause of death.
The cause of death is failure of organs because of injury in the medulla region and severe blood loss. Also, the injury in the arm led to severe blood.
Scroll down, please. Next page.
Loss.
Okay.
And also,
okay.
if once we
the time since death is 8.
Yeah, the time since death is 80 to 90 hours, 88 to 90 hours. Because the body was recovered only after the disclosure statement of the accused
correct.
recorded. Now coming to page PW8, Mr. Vikrant Singh, the testimony before this court is present at page 304. Yes, Your Honor.
Vikrant Singh, correct.
Exhibit PW8A, page number about CCTV recording, drive on 159.
Correct.
Actually, Your Honor, the district judge was of the view that only the exhibit should be marked and let the cross begin because of time, because the time was lacking. So page 169 is the CCTV footage report, Your Honor.
Right. How the CCTV record was proved? Can you tell me, please?
Your Honor, the Resident Welfare Association has submitted a hard disk in front of to the investigating officer. Right. The hard disk is present at page 164.
Got it. How it was proved in the court? In whose statement? Got it. I saw it. Correct.
Yes, Your Honor. So because the exhibit is marked, Your Honor, and the exhibit is at.
I understand that.
Yes,
who has proved this? Who has proved this? In whose statement it has been exhibited? Was it an original one or it was a copy given by the Resident Welfare Association to the investigating officer?
It is the original hard disk which was sealed, Your Honor.
Okay. Now, where do we have this statement that it is an original one? Some witness must have deposed. What is the exhibit of this hard disk?
In the spot Panchnama as well as...
What is the exhibit of this? This hard disk must have been exhibited, no?
No, Your Honor. The hard disk was not exhibited.
So, how do you say that you have proved it? In somebody's statement, it has to be proved that I collected this and this is the same hard disk which was collected by me and it is the original one.
Your Honor, page 163 is
statement
the Panchnama.
Panchnama.
It is not a statement, it is a Panchnama.
Panchnama is when this was collected from the RWA. It was seized.
Yes, Your Honor.
Right?
Yes,
no. During the trial, how and by whom it was proved? Some witness must have appeared to mark it as exhibit. The investigating officer or somebody from
Mr.
RWA.
Vikrant Singh. Your Honor, Mr. Vikrant Singh appeared.
He's the?
He's a manager of the Forensic Science Laboratory, Your Honor.
Okay, fine. Show me his statement.
There is no statement, Your Honor, but only the report of Mr. Vikrant Singh.
Okay, that report has been exhibited. Show me that report.
Page 169 of the LCR.
169, show me. Because the report, if the expert doesn't appear, it can be proved through section 294. No problem.
Yes.
This is the, just read it with me, please, because this is important for your case. Go ahead. Down, scroll down, please.
Your letter number
section 293. Correct. This is a requisition and the covering letter. Go ahead.
Yes, sir.
Something must be after this. I want to come to the main report.
The main report is at page 170.
170. Just a second. Yes. Rajveer Vats opens the car gate and enters the car along with Shreya Shai. Correct. Shreya Shai.
And
scroll down.
65. Yeah.
One by one. Let us. Yes. Scroll down. Scroll down. Next page. Yes. Certificate in compliance 65B. Yes. This is an important document. This is what I was looking at.
Yes,
Next. The main report. Correct.
This is the report, Your Honor. This is the report for CCTV. There's nothing more than that.
No, Mr. Counsel. This is a certificate which is required in the Indian Evidence Act, which proves the report.
That is 65B certificate, Your Honor.
Correct.
However, the report is at page 169.
169.
CCTV analysis report.
Correct. That is important. 65B is most important for proving it. Your 293 is there. Now, the exact. So, what do you want to infer from the CCTV footage? The presence of the accused there?
The presence of the accused. Because I'll corroborate it with the location report, Your Honor.
Right.
The location report submitted by the nodal officer.
Where is the report of the expert of CFSL saying that this is correct in order and it has not been tampered with? That is the most important report. That must be there somewhere. Anyway, just keep it in mind. Make a note of it.
Yeah, but anyways, 65B is present, Your Honor. So
I accepted 65B is only a mode of proof of electronic evidence. This is not 65B is a mandatory certificate saying that this is the chain of and the source of CCTV footage. It itself is not a report. It is only an enabling certificate proving that CCTV footage or any electronic record. I am saying what is there in the report, the contents of the CCTV have to reflect in the report. And the report has to, the forensic report has to say that this was not tampered with, it is in sequence and it is correct technically.
Okay.
That has got nothing to do with 65B.
Your Honor, as far as tampering is concerned, we can match it with the memo which was sent, the forwarding letter which was sent.
Anyway.
The same seal was present while they broke the chain in the broke the seal in the FSL.
Right.
So tampering.
That is. I understand.
Yeah.
I understand.
Yeah.
Somebody has to prove it in the court. No. So anyway.
Yes, Your Honor.
Go ahead.
Then, Your Honor, prosecution witness 11. The statement is at page 306.
Who is he?
He is Mr. Harshit Malhotra, the punch I told you about.
Correct.
Who was the punch in the disclosure statement as well.
Right. What do you want from here? How does it help?
Just to prove that there was a punch while the disclosure statement was made, Your Honor.
Okay. So he's a witness to disclosure statements and all that.
Yes, Your Honor.
Right.
So, and moreover, like, I'll also prove that because of this disclosure statement, lot of things were recovered, like the body was recovered, and hence it becomes relevant under section 27.
Right, so right. Corpus delicti, correct.
Yes, Your Honor.
The body being discovered on the basis of a disclosure statement is the most important incriminating evidence. You want to say that? I got it. Next.
Yes, Your Honor. So, shall I proceed forward with
please.
prosecution witness? So, page number 306, disclosure statement of accused 2 at page 80 exhibited as PW 11-1, seizure memo at page 103 exhibited as PW 11-2, disclosure statement at page 126 is exhibited as PW 11-3, and disclosure statement at page 129 exhibited as at page PW 11-4.
Right.
So Mr. Harshit is a neighbor of Mr. Shubham.
Correct.
He was there near the farmhouse. That is why he's punched in all these statements.
So he supported the prosecution?
Yes, Your Honor. He supported the prosecution.
Good.
Page 83, which is marked as exhibit PW 11-1. Accused to Mr. Shreyansh Rai, son of Lakshman Rai, told us that he was involved in the case apart from the acid attack. They had also killed Shubham Kotak, who was boyfriend of Manu Sharma. The accused guiding us to the farmhouse, the address of the farmhouse, Karolbagh, where he directed us inside the farmhouse. He took us to a second floor, and there in the corner, a big deep freezer was kept, where we found the dead body of Mr. Shubham Kotak inside the deep freezer. On such disclosure, the body was taken out of the freezer. Mr. Harshit Malhotra being the witness here, Your Honor.
Correct.
The body can be seen at page 81, Your Honor. See how brutally he was killed. The whole arm is blown away with the shotgun.
Okay.
And severe injuries to the occipital part of the brain, Your Honor. So that is in corroboration with the post-mortem report as well.
Fine.
The deep freezer was also seized. Also,
Right.
Your Honor, the accused were sent to forensics. Was sent to MLC. So now, just a second, Your Honor. 84. So 84 is the body, and this is the disclosure statement is proved, Your Honor, that by virtue of this disclosure statement, we come to a conclusion that a body was found on the basis of the same, and hence it is relevant under Section 27 of the Evidence Act.
Correct.
Then the disclosure of accused 3 at accused 3, which is marked as PW11/3, page 9. Page 83.
83. Disclosure of?
That is for accused 2, and page 61 is for accused 1.
Come for accused 2, yes. What do you want from this?
Sorry, Your Honor, this is already done. For accused 3, we have
accused 2 is the recovery of body, right?
Page 128 for accused 3.
128. Scroll down, please. Accused number 3, Shubham Sharma?
Yes, Your Honor.
Yeah. What do you want to...
Sharma, son of Ranjit Sharma, told us that he was involved in the case. He was the mastermind of the whole plan. He did all this because he thought his wife was having an extramarital affair with Mr. Shubham Kotak.
Right.
He accepted that he has killed Shubham Kotak with Mossberg 512 gauge shotgun.
Right.
The accused guided us to the farmhouse number 22, the address of the farmhouse. He directed us inside a garden where the gun was buried near a tree.
Correct.
He directed us towards the tree, and where we found the gun.
Okay. So he got the gun recovered.
Yes, Your Honor.
This disclosure to that. Right. Fine. Go ahead.
Exhibit PW11.
Body discovered on the disclosure of the other
disclosure of accused 2.
Gun.
Yes, Your Honor.
Right. Next.
The photograph of the gun is at page 129.
Let me see it. Right. Oh, it's a short gun.
And seizure memo is at page 131, marked as exhibit PW11/4.
131. Right. Who's the witness to the seizure memo? Again, Harshit?
Mr. Harshit Malhotra. Yes, sir.
Correct.
Since all these things were seized from the farmhouse itself, Your Honor.
Correct.
And he's a neighbor, so he was the most close. Also, there's one constable, Mr. Hapu Singh, also as a witness to the
proceedings of seizure and discovery.
Yes.
Right.
So this is how, Your Honor, because of disclosure, we have proved that the body was recovered and the gun was recovered. The gun was sent for forensics and for the fingerprint analysis report and the ballistic analysis report.
Right. What does it say?
The fingerprint report is at, the statement is at page 318. The report is at page 183. 183.
Right. Whose fingerprints?
Your Honor, the fingerprint report of the rod which was seized. So all the 5 fingerprints were sent. All the fingerprint of the accused were sent for the forensics.
Correct. Did anything match?
Yes, Your Honor.
What? Conclusively matched with?
So 5 full partial fingerprint found on the steel rod. F1 conclusively matched with the fingerprint of exhibit 2, accused 1's fingerprint.
Okay.
F2 conclusively matched with fingerprint of exhibit 3, that is accused 2 fingerprint.
Right.
F3 conclusively matched with fingerprint of exhibit 3, accused 2's fingerprint. So on the steel rod, there was fingerprint of accused 1 and 2 only, because the steel rod was used in killing, in harming Miss Manu Sharma, who is victim number 1.
Fine.
Yes, Your Honor. The next fingerprint report is for the gun, Your Honor. And the same is present at page 188.
188, please.
F1 conclusively matched with fingerprint on exhibit 4, accused 3's fingerprint.
Right.
Again, accused 3 in F2, accused 4 in F3, accused 5 in F4, and accused 3 in F5.
Right.
So all the fingerprints of accused 3, 4, and 5 were present on the Mossberg shotgun.
Right.
And that is corroborative in nature. And Your Honor, I'll prove the same with the statement of the eyewitness as well. Moving forward with the prosecution witness 14, who is a ballistic expert in this case. The statement at page 309 and the exhibit at page 175, and the report at page 175.
Yeah, what does he say?
Your Honor, the findings were page 176.
176,
Parcel
please.
1 sealed cloth parcel sealed with seal of PM containing exhibit 1 marked as A. Description and evaluation of firearm. The name model 500 covers an entire family of pump shotguns designed to chamber 3-inch 76 mm Magnum. The cartridge and shell examination. A single 12-bore cartridge was fired from the Mossberg 500 shotgun.
Correct.
The cartridge showed various marks on it, leading to the conclusion that it was fired. Gun residue and distance determination. The cartridge shows riffling marks. There were presence of fingerprint on the shotgun. The fingerprint on the shotgun matched with the fingerprint of Kedar Mishra, Aditya Veer Singh, and Shreyansh Rai. As there was penetration of the
fingerprints of all 3 on that?
Yes, Your Honor. All 3 on the same gun.
That's strange. Chalo, anyway.
There were total 5 fingerprints on the gun. And 3 of them matched with accused 3. And one each matched with accused 4 and 5.
Okay.
As there was penetration of pellets in the hands of the victim, it can safely be inferred that the distance and range from which the shooting took place was under 10 meters.
Correct.
Therefore, in my opinion, the cartridge was fired at the crime scene from the recovered Mossberg 500 shotgun.
Right.
Moving forward, Your Honor, with PW16, who is Jeevan Ram, the location report at page 197. He's a nodal officer.
Okay, for the call records.
Yes, Your Honor.
What do you want to show from the call records? How does it
no,
your case?
The call record also has
nodal officer is for obviously for the call records. Page
yes, Your Honor.
You are saying?
Page 201, Your Honor.
201.
Yeah.
Right. What do you want to show from this?
As per your letter dated 19/9/19, bearing reference number 041219, the desired phone number belongs to Mr. Rajveer Vats.
I got it. This stands proved.
Yeah.
What do you want to prove from this?
The location of the phone on 10/9/9.
Of
just a second,
the phone of?
Phone of Mr. Phone of accused 1, Your Honor.
So
Mr.
you want to
Rajveer
prove
Vats.
his presence?
Yes, Your Honor.
But how this is required? You have an eyewitness. You have.
Yeah, we have just for corroboration, Your Honor.
Okay, right.
Yeah.
More cautious. Right, I got
Yes.
it. So what does it say? It proves the
206
location
is
there.
the location. Yeah.
Right. Show me 206, please.
Block C, Karol Bagh Colony, East Delhi.
Okay. And the place of incident is?
Block
Crime?
C, Karol Bagh Colony, East Delhi.
Crime has also been committed there.
Yeah. Yes.
Right.
Your Honor.
Okay.
Also,
the location
the nodal officer.
presence.
Yeah, the nodal officer of IDEA was also present, who gave the CDR of Mr. Shreyansh Rai. And the location report says the same, Your Honor, that he was also present at Block C, Karol Bagh Colony, East Delhi.
Good.
Page 215.
215, show me. All right.
This is also marked as Exhibit PW 16/1.
This is in respect of the presence of accused?
Shreyansh Rai, accused 2.
Same place?
Yes, Your Honor.
Okay. So these phones were recovered from them when they were arrested?
Yeah, they were arrested. The phones were seized from them. Your Honor.
Seized and seized. Right. Fine.
Yeah.
Okay. So the custody is the chain of custody is also pure.
Yeah, it is not
Fine.
broken, Your Honor.
Right. Right.
Now the statement of prosecution witness 18, Mr. 𝐵𝐻𝐻𝐿, which is present at page 313.
313. Right. What does he say?
Sir, there's some typographical error. It is not 𝐴HMD𝐻𝐻𝐿, it is 𝐴MN𝐻𝐻𝐿.
Whatever it is, tell me.
सर मेरा नाम है 𝐴MN𝐻𝐻𝐿, मैं गार्डनर हूँ शिवम बाबू जी जो बैठा हूँ पहले बेंच पर उनके फार्म हाउस पर. So he also identified the accused present in the courtroom, Your Honor.
Okay.
Whether any statement is recorded by police? जी सर, रिकॉर्ड हुआ है. उस स्टेटमेंट में आपने पुलिस को क्या बताया? सर मैं 4 साल से काम कर रहा हूँ शिवम बाबू के यहाँ. 11 सितंबर 2019 से पहले शिवम बाबू उनकी बीवी अक्सर आया करते थे. मैं कहूँगा हफ्ते 2 हफ्ते में कभी कभार आया करते थे, पर कुछ दिनों पहले 11 तारीख से पहले वो रोजाना आया करने लगे. और उनके 4 दोस्त 11 तारीख को मैं शिवम बाबू को और उनके 4 दोस्तों के साथ एक और आदमी को आते हुए देखा जिसके हाथ रस्सी से बंधे हुए थे और मुंह पर टेप लगा हुआ था. जब मैंने
बोलते हुए देखा तो मैं छुप गया. ये सभी लोग एक कमरे में गए और थोड़ी देर में मुझे एक गोली की आवाज सुनाई दी तो मैं घबरा गया और उसके बाद शिवम बाबू को देखने चला गया. प्लीज स्क्रॉल डाउन. जब मैं वहां पहुंचा तो मैंने देखा कि शिवम बाबू और उनके 4 दोस्त मिलकर एक इंसान को जिसके हाथ में रस्सी बंधी हुई थी उसे मार रहे थे. थोड़ी देर में मैं शिवम बाबू ने गोली मारी और वह मर गए. शिवम बाबू ने मुझे देखा और मेरे गिरेबान पर हाथ लगाकर बोला कि अगर ये बात कहीं गई तो मैं तुम्हें जिंदा नहीं छोड़ूंगा. जनाब, मेरी एक ही बेटी है जिसकी वजह से मैं अपनी गवाही देना में देर करी. शिवम जी का
व्यवहार उनके पति की तरफ कैसा था? शिवम जी से मेरी उतनी ज्यादा बात नहीं होती थी. उनके पिताजी जो कि बड़े मालिक हैं उन्होंने मुझे यहाँ पर रखा था. शिवम बाबू और उनकी पत्नी के बीच बहुत लड़ाई होती थी, अक्सर लड़ाई हुई थी. आपकी तरफ कैसा व्यवहार था? जैसा कि मैंने बताया
11 तारीख के कुछ दिनों पहले वह अक्सर आने लगे थे. अच्छा, आपकी तरफ कैसे व्यवहार था? जैसा कि मैंने बताया गुस्सैल प्रवृत्ति के हैं शुभम बाबू. बात पर बहुत गुस्सा हो जाते हैं. गर्म पानी ज्यादा गर्म हो जाए तो ज्यादा गुस्सा हो जाएंगे. ज्यादा गर्म हो जाए. अच्छा. कोर्ट क्वेश्चन, कभी मारा है आपको? हाथ वाथ उठाया पर कभी मारा नहीं. उनके दोस्तों की कैसी प्रवृत्ति थी जब वो आते थे? जैसे कि मैंने बताया 11 तारीख के कुछ दिनों पहले से वह अक्सर आने लगे थे. शिवम बाबू उनके 4 दोस्त रात तक रुके और फिर सुबह होते ही निकल जाते थे. मैं इतना संपर्क में रहता नहीं था जो इतना पता नहीं. जब आपने देखा तो गोली किसने चलाई? जनाब, गोली तो शिवम बाबू ने चलाई. पहली गोली किसने चलाई ये नहीं पता, पर दूसरी गोली तो शिवम बाबू ने चलाई. ठीक है, राइट.
बाकी लोग क्या कर रहे थे? बाकी लोग जो अज्ञात व्यक्ति था उसे मार रहे थे.
ठीक है, ओके.
So the statement of the eyewitnesses itself very clear, Your Honor. As the body of Mr. Shubham Kotak was recovered from the same farmhouse, and also the gun was recovered from the same farmhouse, and hence we are of the view that Mr. Shubham and his friends were involved in the murder of victim number 3, which is Mr. Shubham Kotak. Your Honor, hence the next witness was the investigating officer of the case who came and concluded it
You must be the last
page 316.
Correct. Just summarize it. What do you want to show?
So, Your Honor, the investigating officer came and told us about the whole investigation. Her statement has also corroborated all the pieces of evidences, whether it may be the FSL report, whether it may be the fingerprint report, whether it may be the medical examination, and how the offenses are brought together. And also, Your Honor, she has made various things very clear. And जैसे कि question number 4 at page 317, Your Honor.
317, please.
ये बताइए कि मनु शर्मा के घर से क्या क्या बरामद किया? वहां से हमने 10 तारीख को ही सब बरामद कर लिया था, कुछ हेसेट की ड्रेस के
Question number 4. Question number 4.
Yes, Your Honor. Yes, Your Honor. Question
number 4, please. You are at 7. Yes. ये बताइए कि मनु शर्मा के घर से क्या क्या बरामद किया? वहां से हमने 10 तारीख को ही सब बरामद कर लिया था, कुछ एसिड की ड्रेसेस और ब्लड सैंपल्स, फिंगरप्रिंट फ्रूट्स, वॉच, लेडीज वॉच, स्टील रॉड रिकवर की थी. ठीक है, हाँ बताइए.
And also about the CCTV, आपकी चार्जशीट में कुछ CCTV का भी जिक्र है. क्या आप कोर्ट में बताएंगे CCTV के बारे में? जहाँ पर इंसिडेंट हुआ था उस घर में के सामने एक वाटर टैंक के पास CCTV लगा हुआ था. मुझे पता चला कि मैंने अपने ACP से रिक्वेस्ट की कि हमें CCTV फुटेज मिल जाए, और जब हमने CCTV फुटेज देखी तो 2 लोग भागते हुए दिखे. CCTV फुटेज ब्लैक एंड व्हाइट थी, जो हम लोगों को कपड़ों का कलर नहीं बता पाए. उसमें 2 लोग भागते हुए जरूर देखे गए.
दिखे. ठीक है.
इसमें आपने बताया कि आप कपड़े का कलर नहीं पहचान पाए. कुछ और बताना चाहेंगे CCTV के बारे में? क्योंकि तनु शर्मा ने भी हमें बताया था कि उसने 2 लोग को भागते हुए देखा था. तो उसके बाद जब हमने CCTV फुटेज से वही चीज देखी तो हमें यकीन हो गया कि 2 लोग घर से भागे थे कार की तरफ. फिर उसके बाद जब हमें मनु शर्मा की डाइंग डिक्लेरेशन रिकॉर्ड की तो उसमें हमें यह भी पता चला कि राजवीर और श्रेयांश वहां मौजूद थे और उन्होंने उसके साथ रेप एंड एसिड अटैक किया. Your Honor, hence on the basis of all these testimonies, we have tried to prove that the accused should be charged under the said sections. Also in the defense evidence stage, Your Honor, when the defense brought their witnesses,
right, I understand.
Yeah,
fine. So you are through with the evidence?
I am through with my part of evidence, Your Honor.
Right. Now, in conclusion, you want to say that you have proved the case by way of eyewitness, by way of recovery of the body and the gun on the basis of the disclosure, by way of the dying declaration, by way of forensic reports of the semen and the fingerprints on the gun, and the matching of the offense of this weapon of offense with the injuries and all that, and the other witnesses, right?
Yes, Your Honor.
Anything
I'll just request you to refer to the defense witness 3's statement.
No, we'll come to that. Let the defense counsel.
Okay, Your Honor. Therefore, the counsel for the prosecution has established the guilt of the accused beyond all reasonable doubt, Your Honor.
The prosecution has established, not the counsel for the prosecution.
Yeah, the prosecution has established.
Right.
It was pleasure arguing before the bench. Yes, Your Honor.
So nice of you. Thank you.
Thank you.
Can I have a 1-minute break, please? For my nature's call before the defense counsel starts.
Yes, sure, sir. Sure, sir.
Okay. Thank you. Thank you.
We can turn off your video, sir.
Yeah, I'm back. Yes, young man.
My lordship,
how are you?
Counsel is from the accused, from all the accused.
Right. For all the accused?
Sir, for all the accused.
Okay.
So, my lordship, as per the story of from the prosecution, my lordship, I'm audible to you?
Yeah, absolutely. Go ahead.
So, my lordship, as per the brief facts of the prosecution has said that 5 accused are there. Number 1, 𝐂𝐨𝐬𝐰𝐚, 𝐂𝐨𝐬𝐰,
Right.
Shubham Sharma,
right,
�ADITYA Singh, and one more is there. So, my lordship, we're coming back to accused 1 and 2, Rajiv and Suryavanshi. I come on later on them. First, I'll talk to from in the point of Shubham, �ԱDITYA and the third one. So, my lordship, charges against them are 302.
Correct.
For murdering the Shubham Kotak. So, my lordship, if you see, the police has made the blunder mistake in the charge sheet that according to them, there are 2 crime scenes are there. One is the house of Manu Sharma and second the house of the farmhouse of the Shubham Sharma.
Correct.
And in the charge sheet, if you see, there is nowhere the site plan of the second crime spot.
Right.
And there is not any picture of the farmhouse. And prosecution has failed to prove that the farmhouse belongs to Shubham Sharma. There is no any proof that the farmhouse belongs to Shubham Sharma. This properties belong to my accused, my client.
Right.
And my lordship, I like to bring your attention on page number 3112, the statement of Ahmad Raza Rizvi, which is prosecution witness 18.
Right, go ahead.
Please come on the page number 314 of the LCR.
Right. What is there on page 314?
So, my lordship, according to the police story, they are saying that they found the body inside the fridge, and the fridge was on the 2nd floor of the farmhouse. And if you see the cross question which is asked by the previous defense counsel, that kitne floor ka farmhouse hai? And the answer is floor ka nahi hota farmhouse. So it means there is only ground floor. So how the police is saying that they recovered the body from the refrigerator that is on the 2nd floor, and my lordship, they won't make any khaka of the gun. They won't make any khaka of the rod, which they are saying that this is the weapon used for killing both the victims. And my lordship, if you see the entire charge sheet, the exhibited documents are not properly exhibited. As per my understanding, the document can be exhibited by the author, the scriber, or who can identify.
So which document according to you has not been exhibited? All the documents?
There are many documents.
You have to show which one.
Yes, sir. I'm showing. Please give me some time.
Yeah.
Registry, please come to the page number 130 of the manual chart sheet. One thirty seven. Please scroll down. Please scroll down. Stop. So, my lordship, if you have a look on that, so I don't believe that that's how we exhibit a document. It is only showing mark A.
I understand. I also noticed it, but now show me. See, there's no problem with a marking. It may be exhibited, but the mode of proof has to be shown. So what is the statement of the witness who has got it exhibited? That is important to see.
That is, it is the statement exhibited only by the prosecution witness who recorded this statement, who gave this statement.
Right, what he has stated to prove it. Come to those lines. Has he stated, this is my statement and bears my thumb impression at point this?
No, sir.
Where? See, it has been written, thumb impression has been encircled and point A has been written. There must be a corroborating statement to this. Come at the top of this statement. Whose statement is this? I see your point, but I have to see whether it is only a technical mistake or actually he has not stated. Manu and I, now where is this mark A mentioned in his statement? Where is thumb impression mentioned? Pastry, can you find out the word thumb impression in his statement?
Sir, it is nowhere mentioned in this statement.
Right, let us see. Right. Scroll down. Right. Scroll down. Scroll down. Scroll down. That's it.
And sir, if you come on page number 292, where the examination is chief given by the Suman Singh, the same prosecutor witness. Here it is not mentioned that statement is given by me.
Come down. Come down. Yes, sir. Just a court question. Right. Point taken. Next.
And sir, there are many things like this that please come on page number 68 registry.
Yeah, tell me.
So sir, this is the report of MLC of accused 1, Mr. Rajiv Vatsa, and it is exhibited by PW6, that is Mukul Agnihotri, who conducted the post-mortem report of 2 deceased.
Correct.
So sir, how can he exhibit this document? He neither the author of this document, he neither scriber of this document, he neither the who can identify this document?
Where is the statement? How is he exhibited? Please come to that statement. Let us read it. This is exhibit.
And please come page number 298.
298.
298 of LCR. 298.
Right. Suman Sharma.
299. 299. Please come.
Statement of Mukul Agnihotri.
Yes, sir. Sir,
you say that he could not have. Okay, just a second. He has proved the postmortem PW 6/A. That was MLC, right?
Yes, sir.
MLC, you say he cannot prove it.
No, sir.
Because he is not the author. But where has he exhibited the MLC? Here. What
Sir,
was the exhibit number of MLC? You check.
Sir, exhibit number is exhibit PW6/A.
That is postmortem.
No,
see
sir, it is not. So it
in
is.
See, in the statement, it is postmortem. Yeah, this one.
But sir, postmortem report, exhibit report number is is PW7. Postmortem.
Okay, so it is wrong here?
Yes, sir.
Is this your signature on postmortem report? Okay. So where is PW7 then? Right, got it. Okay, okay. You have pointed out a glaring defect, right? PW7, who has proved it? Tanishka Jain. Statement in case number this. Oh, it has been, okay. It has been done vice versa. She should have proved the postmortem. Postmortem has been proved by him. And he should have proved this. MLC, he has proved this.
Sir,
okay.
It is not vice versa. It is done it intentionally. This shows that this shows police haven't done work. Take their work seriously.
Okay.
Police have been busy in their some other kind of work while he's exhibiting the document.
Right. Got it. Next.
So they have just narrated, the PPs have just narrated it, them just come and say only yes, which I asked to you.
Okay.
So that I want to bring into your notice, sir.
Right.
And sir, coming back to the statement of the PW18, which is 𝐿�Z𝐝𝐻, who police marked them as a eyewitness of the murder of the Shubham Kotak.
Okay.
On page number 313.
313, right.
Sir, in his whole statement, he didn't mention that he saw that the other two guys firing at the victim, Shubham Kotak. He only said that he saw the Shivam, not
Correct.
the other two.
Okay.
I just want to know that he is not mentioning their name. So what is the role of there in this case? Why police have taken into them the custody?
Okay.
So prosecution has failed to prove that Shivam, Adityaveer and the other one was involved in the case of murder case of Shubham Kotak.
Others are involved?
Sir.
Right. Move on. Next point.
Sir, other name is Kedar Mishra.
Shotgun.
Yes, sir. And sir, police is saying that the shotgun is not is banned in India. So police didn't investigate against the shotgun that where these people came into the possession of that gun.
Nor does it matter.
Sir, they didn't inquire about that.
Whatever it is, the fact is the gun has been recovered. They don't have to investigate from where they got it. They should have done, fine, but if they have not done, there's no problem. I don't see any problem. Yeah.
But sir, Mr. Public Prosecutor for the state keep referring to the disclosure statement.
Correct.
But sir, according to the Section 25 of the Indian Evidence Act, confession to the police officer is not admissible in the court, has no validity.
No, it is not. It is regarding but recovery of the gun, the statement is enough.
But sir, from where they get the recovery of the gun, they didn't make any kind of site plan of there also.
That is something different, right? That point you may raise.
So
correct.
Sir, from these points, I want to show that police didn't take their work seriously and have done many mistakes in the investigation.
Shoddy investigation.
Yes, sir. A man has lost his wife and they are keep accusing him for killing his wife. Sir, the most important, I like to read out the section 300, that is for murder.
Tell me.
So according to the Indian Penal Code,
murder,
except in the cases hereinafter expected, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death. But if it is done with the intention of causing death, the prosecution has failed to prove the intention. From that come from what is the motive behind that? There's pointing out that he has doubt that his wife is having affair with Shubham Kotak. Police didn't inquire about that affair, that how he triggered out that she is having affair with him.
Right, I got your point. Now listen to me. We have an eyewitness who has seen the victim being shot, that person from the farmhouse.
Yes, sir.
In the presence and when we have a testimony of an eyewitness, isn't it a law that motive pulls into insignificance? Motive is important in case of a circumstantial evidence. But sir, once you have tell me.
Sir, please complete, sir.
No, I was saying, in a circumstantial case, motive is of prime importance. But once we have an eyewitness, they have galore of judgment saying that in case of eyewitness, the motive, even if the motive is not proved by the prosecution, that will suffice. Now, carry on.
I want to show some light on the contradiction that they are having on the eyewitness in the police story.
Correct.
Sir, as he answered to the question that कितने floor के होते हैं, कौन से floor पे देख सकता, he said that floor पे नहीं होते हैं. And police is keep on saying that they recovered the dead body from the freezer from the second floor.
Second floor, okay.
तो कहाँ पे second floor and कहाँ पे है ही नहीं second floor.
और site plan भी नहीं है.
Site plan भी नहीं है, sir, and no photograph of the farmhouse, and not this, sir, they didn't seize the registry of the house, from which they can prove ownership that the property belongs to Shubham Sharma. And sir, they didn't find any kind of CCTV footage from that place. And no other person that who can say that yes, they are coming and they are going.
Okay.
And sir, they involve the section Section 364. So sir, I want to read it out. Sir, 364 is kidnapping or abducting in order to murder. Whoever kidnaps or abducts any person in order that such person may be murdered or may be so disposed of as to be put in danger of being murdered shall be punished with imprisonment for life or rigorous imprisonment for a term which may extend to 10 years and shall be liable to fine. So, since they have abducted the Shubham Kotak, that no one filed a police complaint against him that Shubham Kotak is missing. Police didn't investigate that also. So, sir, in my point of view, police have just investigated and saying that it is a one-sided case, which they have to cut off their burden from doing any kind of further and solid investigation. They are putting all the blame on the husband of the victim, Shubham Sharma. And that is, they fail to prove that he is having anger against his wife, that he planned such kind of things. From which proof they are saying that he is having doubt on that.
Okay.
And sir, coming back to the FSL reports, which prosecution is referring, I want to refer again, if you allow me, sir. Registry, please refer to the page 176 of the LCR.
176 for the lower court record, please. 176, what's that?
So this is the ballistic examination that more than 500 students fired.
What do you want to show from it?
Sir, it shows that only a fire is been done from that pistol, from that weapon.
Okay.
It is not showing that from this piston, the Shubham Kotak is murdered. And my accused, that is Shubham Sharma, Aditya Veer Singh and Kedar Singh, has fired the pistol. So it is nowhere is written that these guys are fired at Shubham Kotak.
What about the eyewitness? How the ballistic report will say that ballistic report cannot prove who shot it. Ballistic report can prove the bullet recovered from the spot, the shell recovered from the spot, and the bullet found in the body has been shot from this gun.
But sir, police didn't recover any kind of bullet from the victim, from the deceased.
In the post-mortem also no bullet was recovered?
Registry, please refer to the 108 page number
of the LCR?
Yes, sir. $109. Sir, it is the post-mortem report which is exhibited by PW7. which I believe in my sense that he is not the competent person to exhibit this post-mortem report.
Right.
Because PW7 is the person who conducts the MLC of the victim.
Now let us see. Post-mortem report shows a recovery of any bullet found in
No,
the body.
sir. No, sir.
Right.
And even, sir, please see the cause of death. Please look at the cause of death. Please, Registry, please come to page number 114.
Just read it loud. Cause of death. Read it. You have it?
Yes, sir, I have it.
Read it loudly.
Registry, please come to page number 122. It is 122, no? 118 of the manual charge sheet. 118. Registry 118. Yes, please zoom in. So, sir, it is clearly mentioned the cause of death is failure of organs because of injury in the medulla region and severe blood loss. Also, injury in the arm led to severe blood. There is no mention of that he's been shotted.
He's shot will not be in the opinion. It will be in the postmortem. The nature of injuries. See the nature of injuries. Postmortem, please come on. Where are the nature of injuries? Injuries. See, read this.
But sir, from the nature of injury, we weren't able to identify that whether that injury is come from the result of the shot, from the bullet.
Okay.
Has to be there, sir.
Just a second. The muscles are ruptured, severe hemorrhage and blood clotting in brain and skull. The arm is severely damaged and the muscles are damaged. Right shoulder fracture. Just a second. Right shoulder fractured, knee and both mandibles dislocated. Now this is important. Powder tattooing on shoulder and neck. This shows gunshot injury. Chalo, next. Can you scroll a bit down, please? Yeah, that's it. Little more down, please. Next page. Next page. Down. Down. Yes. Right. Okay. Carry on, Sapni.
So, sir, in my point of view, that if police lying on the eyewitness, I believe he's totally lying, that he didn't see anyone shooting Mr. Shubham Kotak. Because they are not like coming on the same point.
Okay.
He's saying that the floor is missing and police is saying that they recovered the body from the second floor.
Okay.
So, sir, from that, I want to show that my clients, Mr. Shivam Sharma, 𝐶𝐶 and Kedar, didn't shot Shubham Kotak.
Okay.
They are
They're absolutely innocent.
Yes, sir.
Okay.
And, sir, my client, Mr. Shubham Sharma, has lost his wife due to some incident, and the police pressurizing on him to accept his crime against her. So how it is valid, sir?
Right.
And my point is that, sir, police prosecution has failed to prove the motive that the Shubham Kotak and the deceased Manu Sharma was having affair. They didn't inquire about that fact, that how he get triggered.
Okay.
So, sir, I want that you please note some points that I want to show. That first is that police didn't make any side plan of the crime scene. Second,
see, I've noted down. If I'm wrong, just correct. One is no second side plan.
Yes, sir.
The side plan of the recovery of gun is not there.
No, sir. And
post-mortem versus yes, tell me.
No khaka of the gun.
No khaka of the gun. No sketch of the gun. Sketch of gun. Okay. And post-mortem versus MLC controversy, PW7, that it has not been proved.
Yes, sir.
Motive has not been proved.
Yes, sir.
Contradictions in the testimonies.
Yes,
sir. Floor controversy, the farmhouse, the witnesses, only ground floor is there. And the police has said that they have recovered from the second floor. Site plan, second site plan, thus is important. Then ownership of Shivan's house is not proved. And there is no CCTV recording also. Right.
And so no other independent witness has seen
what?
The kidnapping or abduction of the Shubham Kotak.
What about that farmer? How do you impeach the testimony of that farmhouse employee? That servant?
But other than him,
he's also how can you say he's not an independent witness?
Sir, he have
quantity of testimonies is not important. It is the quality of evidence which is important.
My lordship, my point is that he only saw these five are taking up inside the house.
Okay.
Bringing the deceased.
And he also says I saw them shooting.
No, sir. I want to say that no one saw that while they are abducting the deceased Shubham Kotak.
They are taking him into the house forcibly with his hands tied. What more is required to prove abduction? He says, हाथ बंधे हुए थे, वो लोग आए, अज्ञात आदमी को मेरे सामने ले गए, और फिर उन्होंने गोली मारी. He gives a graphic description of किसने मारी, किसने shoot किया. Is it not enough to prove abduction and murder?
Sir, in my point of view, if we think from the common sense, sir, if let's suppose if my clients were shorted the deceased Shubham Kotak, so why they leave the most important witness against them living?
So you mean to say they should have killed him also?
Sir, if they have the criminal mind.
Okay.
But from this, I want to say they don't have the intention to kill anyone. They are innocent.
Okay, I got your point.
As the prosecution saying that they are unethical persons and are criminals on the earth. So I want to say that they don't have that kind of criminal mind.
Okay. If they were criminal, they would have shot the eyewitness also, you mean to say. They would not have left him against them. Correct. I got your point.
It could be a point.
Right. Okay. Anything else?
Yes, sir. There are many more things.
Tell me, please. Just hurry up, please.
Sir, I will take quite some time, but I'm trying. Sir, please allow me.
Right.
I beg your pardon. Sir.
Do it.
And sir, coming back to the accused, till now I proved the point against accused 3, 4, and 5. And coming back to the accused 1 and 2, as I told you, I come later on it. Which is Rajveer and Suryavanshi Rai.
Okay.
So they have been charged for 302 and 376 and 326A against Suman Sharma, deceased Manu Sharma. Suman Singh, victim Suman Singh, and deceased Manu Sharma. Registry, please come to the page number 56 of the LCR.
Final opinion.
No, 56 of the LCR. It is 56 of the LCR.
What is the document? You tell me the name of the document. The description of the document. What do you want to show? It is 56. You tell me orally what you wanted to show.
57.
Next page. Dying declaration.
Yes, sir.
Okay.
Sir, I want to show some light on this. That this is the dying declaration, and it can be the solely source for conviction, my lord. But sir, here you notice the mistake. Who is recorded the dying declaration? The IO, the policeman. Why police didn't request magistrate to come and take the dying declaration?
Okay, they may not be having time. They may be thinking that she will not survive by the time we call it.
But sir, it will again.
Right. You mean to say the police officer, the dying declaration given to a police officer is not admissible. That is what you want to say?
Sir, it is admissible. There is no bar. But it again come back to the authenticity of the dying declaration.
Correct. Right. Now, just come to the bottom of the dying declaration. Let us see. Go down, go down, go down, go down. Next page. Go down. Yes, go down. Go down. Go down. Go down. Down. Just signatures. Medical. Just. Okay. I, Pratisha, certified that the declaration was recorded by me, and I also certified that the declarant Manu Sharma maintained her sound state of mind throughout the dictation of a declaration. The recording ended at 9:50 AM. Signature, the name of medical practitioner Shubham Mishra. Who has recorded it? Who is Shubham Mishra? Medical practitioner.
Shubham Mishra is the doctor.
So, she has certified it? The doctor has certified it?
So, sir, I like to show some contradiction on it. If you
that is different. But first, we should be clear on this point that it has been recorded by the IO in the presence of the doctor who has certified it.
Sir,
so that way, there's no problem. Yeah, show me the contradictions.
Open the synopsis which is submitted by the public prosecution.
I have it. Which page? Which page?
Page number 15, sir.
15, right. Just a second.
So it is the case Charan Singh versus State of NCT of Delhi.
Yes.
And here it is mentioned in dealing
with the dying declaration, the court has to bear following if these requirements are satisfied, conviction justice even without corroboration. It has observed it cannot be laid down as an absolute rule of just a second. Absolute rule.
Come to point 5, which I want to point it out.
Just a second. Point 5. Okay. That a dying declaration which has been recorded by a competent magistrate in the proper manner, that is to say in the form of question and answer, and has as far as practicable in the words of maker of declaration, stands on a much higher footing than the dying declaration, which depends upon our testimony, which may suffer from all infirmities in human memory. And okay, fine, I got your point.
And sir, please come
that is a very weak defense. Many judgments have come thereafter also. Okay, tell me.
Sir, please come back to the dying declaration again.
Right. Show me.
So, sir, here also the Dr. Shubham Mishra has mentioned that he is competent enough to give his statement, right? So, sir, please come to the post-mortem report of the deceased Manu Sharma. I'm just referring the page number.
Page?
page number 108 of the LCR.
Postmortem of
Manu Sharma.
Right. What do you want to show?
Registry, please come on page number 112. Please rotate it.
What do you want to show? Read it, read it.
Registry, please rotate it.
It can't be rotated.
Okay, no problem.
Sir,
I got it, you read it. You
Sir,
read
please
from your
note it.
record, what do you want to show?
Page number 20. Mouth, osphagus and condition of teeth.
Correct.
Sir, and please, what is the answer of this? Bleeding from tongue. So, sir, if the bleeding is continuously from the tongue, so how is capable to direct the statement? How the police gave, how the doctor say that he is competent enough and he is okay enough?
Did you cross-examine the doctor on this point?
Sir, I was not there at time. There was some other.
Whoever has done, has he cross-examined the doctor at this point? That you must have seen while preparing your arguments.
No, sir.
If he has not been cross-examined on this point, then nothing goes. You have to cross-examine. You have to confront the doctors on these points, which you are arguing here. If it is not done, then his testimony goes unimpeached, unchallenged. Next.
But sir, this is the contradiction I want to bring
Right.
in front of
Got
the
it.
honorable court that.
Got it. Got it. Next.
And sir, coming back to the statement of the PW2 of the Tanu Sharma. On page number 25 of the LCR, registry, please come.
25. Okay. This is Rukka?
Yes, sir. And which is executed by the PW2 also.
Tell me.
So, sir, it is clearly written that she saw two people running outside the house. She didn't saw that these are the two persons who is raping her sister. So just coming out from the house, it doesn't mean that they are that person that who raped their friends. So sir, it is my point that they didn't mention in this statement and the statement which is given in the examination chief. It is not clearly mentioned here that she saw that the accused 1 and 2 raped her sister. So this is the point I want to bring in.
Right.
And so coming back to the MLC of the accused 1, which Mr. Public Prosecutor for the state keep on saying that we have seen the struggle that how the victim is doing. It leaves the marks on the body of the accused 1 and 2. So sir, Registry, please come to the page number 58, manually. This is the LCR. Please come on the 58 of the manual charge sheet. Yeah, this is the 58. Sir, please see the date of the arrest. It is
13/9/2019. Okay.
And the act was conducted by the police that it is 10/9. So they arrested him by 2 days later.
Fine. What do you want to say?
So sir, I want to say that they must have some sexually active or sexual life also. So they have gained the marks from that activity. What is the proof that they have gained these marks from only her?
The DNA is matching. Semen samples are matching from vagina and from the accused.
Sir, if you see the page number 66.
66, please.
Manually.
Manual 66. 2 page down. Yes.
Sir, please see, there is no photo of the accused.
See, identity is not in dispute. Where is the dispute of identity? She has identified by name, dying declaration, everything. See, it is not a case in the darkness someone came and raped and went away. Next.
And sir, if you see the entire MLC report of accused 1, it is not clearly mentioned that he is capable enough to do a sexual activity.
Where? Show me that. Where?
Sir, if you see the opinion.
This same page?
Sir, page number 76, manually 76.
76. Come to 76, please. Manual 76.
Yes. Sir, if we read this.
Just a second. Let me read it. Please scroll down. Opinion you want me to read?
Yes, sir.
Taking into consideration history of case, the date of penal and reported the possible of performance of sexual intercourse of vaginal under cannot be ruled out. It is clear.
So, sir, on what basis they take the test of potency?
Just a second. The possibility of performance of sexual intercourse, that is of vaginal, anal, urethral, oral, by male sex organ of Rajveer Vats's reference cannot be concluded or excluded. Cannot be excluded. It is excluded. So it is clear. He is capable of sexual. Tell me what do you want to say?
Sir, if we come on page number 75.
75.
Scroll up.
Scroll up. 75, please. This is 75. Correct.
Yes. Please come on to page number 8. Point 8.
Okay. 8. 2 buckle swabs and 2 slides.
No, point 8. Niche. Please scroll down.
Scroll down, bhai. Acha, okay. Scroll down. Yes. Test advice for potency.
Yes, sir.
Glucose tolerance test. Serum creatinine.
My question is, where is the report of these tests?
No. These reports are not never shown. It is only a conclusion that is there. Always. And this you had to, if you had to challenge this, the defense has to cross-examine the doctor when he appears in the witness box. These reports or these tests are never a part of this. Only the opinion matters. The conclusion matters, and always the conclusion is there in the opinion. And again, cross-examination, yes, you can ask all these questions that I think you have not asked. See, now everything comes down to your cross-examination of each of the witness. Now, this is the report. This is the report by a medical expert. Now, you want to contradict this report. It has to be the best place to contradict would be by way of cross-examination of the medical witness. Now, go straight to the cross-examination of this doctor. As a defense counsel, what cross-examination has taken place? Let us see that. So, sir, otherwise, all this, you cannot impeach the document itself. You have to impeach the testimony of it.
Sir, in this report also it is mentioned that they took the sample of the semen.
Correct.
Correct, sir. Registry, please come on page number 198 of the LCR.
LCR. What is that?
Sir, parcel report.
This one?
Yes, sir, this one.
Chain of custody. What do you want to show? Tell me.
Rishit, please come to page number 194. Sir, this is the end of the document which is exhibited by the
Correct.
person. I want to say that please come on the first page number of this report. So, sir, this is the report.
First page of this report. Which is the first page? Which page?
194 of the LCR.
194 of LCR. Okay, this is the. Now, what do you want to show?
Sir, these are the report of the. These are the parcel report. What evidence, what exhibited docs are gone for the forensic.
Correct. Now, what do you want to show?
In this report, sir, there is nowhere is mentioned that the semen is going for the verification.
How can you say that?
Sir, if we read this report.
Just a description articles contained participle. One seal cloth. Just wait, please. CMO clothes described Sharma. Red salwar having brown strings, partially burnt, brown color. Next, the black color underwear. Next, parcel 2, one sealed parcel, seal of CMO containing closely described the clothes undergarment victim number 2. Blue pajama having brown stains. Green salwar having brown stain. Red color bra. Black color underwear. Next, one seal cloth parcel, Rajveer, okay. Next, black trouser, black. Okay, next, one seal cloth, trouser, underwear, white vest. Next, one seal cloth parcel with PM containing exhibit plastic dibbi magi. What is this? Cotton wool swab with brown flask described as blood lifted from the spot. One seal cloth, PM containing exhibit in plastic dibbi. 𝐷𝐾𝐶, cotton wool swab with brown flask lifted from the spot. Next, one seal cloth parcel with PM containing exhibit 7 kept in glass bottle. This must be semen. Glass jar containing concentrated hydrochloric acid lifted from the spot. One seal cloth containing exhibit plastic dibbi markage. What is this? Cotton swab described as stains found body. The seal cloth parcel sealed with the seal of containing dibbi. Next, cotton wool swab described oral swab. Correct. Next, one seal cloth parcel sealed with, just a second, sealed with CMO hospital, glass bottle, cotton wool swab described blood testing, seal cloth parcel, dibbi, wool swab, CMO, plastic dibbi. Next, cotton wool swab described in acid stains. Next, acid, just scroll down please. Yeah, cotton jar contained described acid collected from the car. Next, scroll down please. Yes. Containing exhibit plastic dibbi. Yes. Next page. Scroll down. Just a second. Seal from CMO. Clipping of hands. Plastic dibbi. Mark this. Describe blood gauge. Plastic envelope. Swab. Describe vulval swab. Right. Scroll down. Collected from the cotton swab. And now see the results. Now result of analysis. Scroll down, please. Now just a second. Blood was detected in this, semen was detected in this, H2SO detected. Next. Regarding query number 11, separate, just see, separate will be published, separate serological report will be provided. No, these serological reports are important. Semen has been collected. Next, chalo, aage batao.
But sir, where it is in the chart sheet is not mentioned that the semen of I'm asking
you
for
want to say that it is nowhere it is proved that semen was collected from the accused, right?
No, sir. I want to say semen is collected. But where is the matching report that
exactly semen, this is serological report will be there. Is this report there or not? And see that statement of this witness.
But sir, now, this report is not there and it is not exhibited.
Okay. You mean to say serological report is not there?
Yes, sir. And it is not exhibited also.
Fine. Okay. But we have a dying declaration of the victim saying that these persons raped me. Supreme Court says that is enough without even medical evidence.
But sir, I want to say that why, if the dying declaration is enough to convict the accused, so why did request magistrate to come?
Fine, I got your point.
It is the Supreme Court also laid down some guidelines regarding
right.
this.
Supreme Court says it would have been better if the magistrate was there.
Yes, sir. The
it would have been
authenticity
strong, but Supreme Court doesn't say that without the magistrate presence, the entire declaration can be thrown out. I got your point.
It could be challenged that it is not recorded by the magistrate.
You said it. Got your point. Next. So you say 𝐶𝐮 report is not there?
Yes, sir. And sir,
okay.
Again, I come to the car.
Car, what?
That according to the prosecutor, public prosecutor for the state says that they recovered the car of the accused, disclosed the statement of the accused one, Rajveer. So, sir, they didn't inquire about the car also. They haven't seen the RC of the car. So, from what basis they are saying that this car belongs to my client?
Okay. So, see, the ownership of car is not proved, you say?
No, sir.
Right. Ownership of car not proved. Okay. Right. Next.
Sir, I'm just dragging your attention on the PW witnesses.
Which one?
So just give me a moment.
Yeah, please. But when the prosecution was arguing, you must have kept yourself ready, no? It is so simple now. After hearing the prosecution, you can match the prosecution point by point.
Yes, sir, but it is difficult while having online argument.
I understand. I give it to you.
Because of the page combinations.
No problem, young man. Take your time. I'm with you. Don't worry. Defense should be given all the opportunity to defend itself. The right of accused is very important in that fire. Howsoever the gruesome the crime is.
Sir, if we come statement of the Manvinder Raj, that is on page number 308.
Page number 308, please.
309.
309. What do you want to say? He's from forensic?
Yes, sir.
What do you want to show from him?
Sir, so please read the question. I'm just reading out the questions which is asked. So, आपको parcel कब मिला था? 13 September the answer. And what you received exactly? I received the parcel which consists of shotgun, which was pumped. It was Mosaic 500. And any other thing, just one parcel. There is also stated that bullets are also recovered. Obviously, cartridge will also be provided.
Right.
How many number of cartridges were there? I can't remember the exact number of cartridges.
Probably 2-3 cartridges. Right. What is the length and breadth of cartridges? So Mosaic is US manufactured gun. The gun powder was also there. The barrel is of 14 inch and bullets were 2 to 3 inches. Correct. There was a mention that fingerprints was also there. Scroll down, please. Whose fingerprints were they? I can't remember the exact name, but there are 3 accused whose fingerprints were matched. Question: ये भी एग्जामिन किया जा सकता है कि किस हाथ में गन पकड़ी गई थी? क्या आप बता सकते हैं कौन से हाथ में थी? आंसर: आई डोंट नो. कोर्ट क्वेश्चन: क्या लेफ्ट और राइट हैंड के फिंगरप्रिंट सेम होते हैं? आंसर: हाँ सर. कोर्ट क्वेश्चन: आप बैलिस्टिक एक्सपर्ट हो या फिंगरप्रिंट एक्सपर्ट हो? सर, बैलिस्टिक एक्सपर्ट. ओके. What do you want to show from here?
So sir, he is saying that he is ballistic expert. So how he exhibit the document which is fingerprint report?
Where is he exhibited?
Sir, he is exhibited.
Okay.
And right. See the answer. क्या left और right hand के fingerprint same होते हैं? He answered that हाँ sir.
नहीं हो सकते.
Sir, how it is possible that the fingerprints of the both hands are same?
Correct. ठीक है. Okay, got your point.
We see how they prepare the fingerprint and how they matches how the one-sided investigation is carried on.
Short investigation.
Yes, sir.
Okay. Next point.
And sir, coming back to the again, I'm reading the section 30, which is murder. So sir, if we believe that my client have done this act, so prosecution has failed the intention.
See, you are concentrating more on the part of murder. I understand it. First, you have to tide over the rape part also. It's a rape come murder.
But sir, how they prove rape? The semen is not matching.
Okay.
They are saying that they're matching, but where is the report? Okay. Which is there? And if there is something,
and the dying declaration of the victim, you say, is not reliable because it was not registered, recorded in presence of the magistrate, right?
Sir, I would say it is totally influenced.
Okay. How it is influenced?
Sir, because IO conducted this dying declaration.
And recorded it.
Because
so investigating officer was an interested party, so he could have recorded the statement according to the prosecution, and it was an influenced one, right?
Yes, sir.
Hence, magistrate was required. Magistrate should have been called to record the dying declaration of the victim, right?
Yes, sir.
Fine. And for murder, you say, right. Now come to murder 300, section 300 you were reading.
Sir, the intention. Sir, the intention is, prosecution failed to prove the intention, that whether they come with the intention to murder the victim, they didn't come with, the prosecution failed in any statement of the prosecution witness.
Now again, I'll come back to that. Just tell me one thing. Once they have brought, you have an eyewitness at the farmhouse saying that person was tied back with his hands were tied back, and all these people brought him to the farmhouse and they shot him there. So what more is required unless you impeach the testimony of that eyewitness? What more intention is proved?
Sir,
they had
as we clearly see the contradiction between the police story and with the statement of the eyewitness, they are not matching. Police story, according to the police story, they are talking about some other property, and the eyewitness which are claiming that he is the eyewitness, he's talking about the other property. So how can he be the eyewitness that if they are talking about the other two different properties?
Okay. Okay, fine. Next.
Police didn't prove that the location of the eyewitness is also there at the crime scene. They must have investigated, they must have proved with the CDR report that he is also there at that time.
So you mean to say the eyewitness, the phone records of the eyewitness should also have been brought on record?
Yes, sir.
Right. Now, once the eyewitness has deposed, the onus of burden and the burden of proof by the prosecution was offloaded, and it was you to prove that he was not present on the spot. They have led their part. See the cross-examination of that witness. Come to that eyewitness cross-examination.
Sir, I only get this cake almost a week ago.
I understand. See, but once you are arguing, you must be ready. That cross-examination, all these witnesses cross-examination must be seen. See, you are, I understand your points. I have written down your points also. But at certain point in time, at a certain moment, you have to check whether by way of cross-examination, the credibility of the witnesses have been impeached or not. That is the mainstay of a defense performance.
Yes,
see, I got your point that semen one issue is there. But then you have a problem of a dying declaration, which you have tried to demolish. But in my opinion, that cannot be, because much water has flown since then. And so many judgments have come till 2019 and 18 that investigating officer recording a dying declaration is absolutely not wrong. And especially, we have cases where even the doctor was not present. That courts have also accepted. In this case, the doctor has certified that she was fit to give a statement.
But sir,
yeah.
But sir, on the same hand, if we see the post-mortem report, that which clearly shows that bleeding from the tongue. So
I
how
understand. See, so now where the doctor has been cross-examined on this point, it is only a medical expert who could have said that because her tongue was bleeding, she could not have given a statement. Me and you, being not medical experts, cannot comment on this. That is why the purpose of cross-examining the medical witness. So that is why that doctor, you should have asked, I'm sorry to say, the other counsel who had conducted the trial should have asked a question supported by medical literature. Sir, under these circumstances, when the tongue is bleeding, it means that tongue is cut, and whether she could have given a statement under these circumstances. Then the doctor must have said, or would have said that no, it was not possible, or it was possible. So in the absence of that cross-examination, the Dine declaration cannot be impeached. You must try and understand for your future reference also. You will be going and practicing in the actual courts also. Then this also, defense has to impeach the credibility of each and every witness by way of cross-examination. Nice. Chalo.
Sir,
see, this is only for the purpose of your education.
Sir, I do agree with all your points. But sir, I'm just trying hard to get...
No, you are doing your best. No problem.
Clients. So sir,
issue is not of that you are trying hard. Issue is that what in a criminal trial, and especially when is a rape ka murder trial, how the defense has to be careful in cross-examination. Entire cases, see, in a criminal case, the burden is very heavy on the defense to offload it. Yes, I understand the prosecution has to prove its case beyond doubt. But then to impeach the credibility of documents and witnesses is the duty of the defense counsel, who is cross-examination and performing the trial. Now, come on, next.
So, sir, from these points, as you said, I'm pointing out again and again the Dine declaration. From this point, I just want to say this, that police didn't done his duty properly.
Correct. Shoddy investigation.
Yes.
Correct.
And there are many things which has to be done and they have not done.
Correct.
So, sir, on the basis of shortened investigation, it would be injustice for my clients that these people are convicted for the offense which they haven't committed.
Okay, fine. Next point. Anything else?
No, sir.
No, now let me summarize what you have said. Once again, for the closing part, right? First is no second site plan of the spot. This is in relation to the one witness saying that farmhouse only had one floor.
Yes, sir.
And the police says the body was recovered from the freezer in the second floor of the farmhouse, right?
Yes, sir.
Second is,
I'm adding to it, they are saying that they found the dead body in the refrigerator.
Correct. On the
whether they find the ownership of the refrigerator also, who brought the refrigerator.
That is not required, young man. Chalo, next one. No site plan of the gun recovery and no sketch of the khaka of the gun, right?
Yes, sir.
Post-mortem versus MLC controversy?
Yes, sir.
Then motive not proved according to you?
Yes, sir.
Contradiction in testimonies?
Yes, sir.
Floor, farmhouse I've said. Ownership of Shubham's house not proved?
Yes, sir.
No CCTV footage collected?
Yes, sir.
No witness to, kidnapping. No witness of kidnapping, right?
Abducting.
Abducting, yeah, that's same. Bleeding tongue. So how she could give Dine declaration?
Yes, sir.
Then semen report and ownership. Okay. Semen report is not there according to you. The ownership of the car.
Semen matching report.
Semen matching report. Matching report. Semen. Right. Then you have the ownership of the car not proved of your client.
Yes, sir.
Then ballistic. Okay. Ballistic expert cannot prove fingerprints. Right. Got it. Fine. That's it.
Yes, sir.
Bolo. Anything else?
Sir, they are not only with controversy of MLC and post-mortem report. There are some other controversies also regarding with exhibiting documents.
Exhibiting documents. Yes. Which is
Mr. PP referred to the picture of the Shubham Kotak, disease Shubham Kotak. So how he referred to that, it is not exhibited also.
Correct. The exhibits have not been proved according to the Indian Evidence Act, right?
Yes, sir.
The procedure of exhibiting documents is faulty and they cannot be read into evidence. This is what you are saying.
Yes, sir.
Fine.
Sir, the documents are only executed by the author, scriber, or who
correct. Only by author.
Right. Give me just 1 second time. I will bring some 2 points also.
Okay, tell me.
Registry, please come on page number 312.
312.
So it is the statement of the Chand Prakash, who exhibited the document, is location report of Rajveer.
Okay.
So sir, please read the first question. क्या आप एग्जैक्ट लोकेशन निकाल सकते हो? हम एग्जैक्ट लोकेशन नहीं बता सकते, बट उस एरिया की सराउंडिंग एरिया बता सकते हैं.
That is a given case, I understand. That is always there. ठीक है.
बट सर सेकंड, बट यहाँ तो मेंशन है कि 2 एग्जैक्ट लोकेशन है. तो या बिकॉज देयर आर 2 or 3 towers through which we can put up the
coordinates. Correct.
Coordinates.
Fine.
How many towers to coordinate at a time? 2 or 3.
Right. What do you want to say?
Sir, same to the page number 1010. 3010. 3010.
310?
Yes, sir.
310. Correct. Come.
Sir, he is also a location expert who gave the CDR report.
Which question?
Sir, if you give me time, if you allow me, I can read the entire statement.
Read it if it satisfies you.
आपने लेटर कब रिसीव किया था? I got the letter on 19 September. Can you tell me the reference number? I do not exactly remember, but it is around 4012. आपने कैसे पता लगाया कि यहाँ नंबर उसी का है जिसको आपने मेंशन किया है? The phone number was registered on the name of Shirans Rai, so there was no confusion regarding that. आपने उसमें लोकेशन के बारे में बता रखा है. There is a procedure in which we get to know the location of any particular person because हम लोकेशन ट्रैक करते हैं. जो नियर बाय टावर की लोकेशन होती है उसके कोऑर्डिनेट सेट करते हैं कि कौन सा पर्टिकुलर एरिया में मोबाइल फोन है. आपने कितने नंबर की ऐसी डिटेल्स ये सब निकाली? मुझे एक ही फोन नंबर की डिटेल्स निकालने के लिए बोला गया था. I did that and that was of Shirans Rai.
ठीक है.
आपने डिटेल निकाली वो कौन सा टावर था? That was of Karol Bagh region 3. Towers were from Karol Bagh region. Exactly कहाँ पर था exactly? I do not remember. It is on record. Court question. मैडम, इट इज करेक्ट दैट जो आप लोकेशन निकालते हो 3 टावर के बीच से निकालते हो, सर कोऑर्डिनेट्स निकाले जाते हैं. कोड क्वेश्चन. वो टावर्स आपस में कितनी दूर होते हैं? आधा 1 किलोमीटर, आधा 1 किलोमीटर होते हैं, राइट? सो पर्सन कुड बी एनीवेयर इन दैट एरिया. सो यू डू नॉट गेट एग्जैक्ट लोकेशन. I correct to say that? So answer is yes. So they do not have that location of the my accused is the same. Again, the contradiction.
Exact location cannot be there.
Yes,
but
sir.
Everybody knows. Correct. But the surrounding area, see, call records and the location is only a corroborative evidence. It cannot be the evidence. It cannot be the main evidence. It is in supplement to the other evidences collected by this. So this is also one of the evidence showing that the person was present in the surrounding area at that point in time. So along with other evidences, this is only a corroborative. This does not, it cannot be an independent proof by itself. That I understand. Right. Next. You drove your point. Correct. That's it. Anything else? Defense is never satisfied.
Sir, I'm just bringing 2 or 3 things also.
Yeah, tell me.
Regarding the exhibited documents.
Okay.
Sir, I'm not getting the name of PW10. Who exhibited site plan of the crime scene C22 Karolbagh.
You find out. PW10. The registry searching. It's not there.
Yes, sir. So how he exhibited the document?
Then search it by site plan. IU must have approved the site plan. Site plan.
No, sir, it's not there.
Okay. That is strange.
On page number 32. Please come to page number 32.
Of?
LCR. Sir, this is the site plan.
The first one.
Yes, please scroll down. Sir, we see it is exhibited by PW10. But
the PW10 statement is not there.
No, this
Your
is
Honor,
not record.
if I may.
Yeah, tell me. That's important.
There are some issues with the exhibits marked. Please refer to 305.
305.
Actually, the statement of prosecution witness 6 is missing from the whole list of statement, Your Honor. So that's why, because of that only, Rupesh Singh was prosecution witness 6, and because of that, the whole mistake of prosecution witness 7, post-mortem and...
so you tell me, who has proved the site plan? Can you tell
page
now?
305, Mahesh Kumar. It is
Just
mentioned prosecution witness 9, but he is prosecution witness 10.
Okay, but where does he say the site plan? Okay, you mentioned the map that the car was...
Signature, page number, a scaled map.
Okay. Right.
So, because of the missing prosecution witness 6 statement, Your Honor, the numbers are shifted above.
Numbers are shifted. Okay, fine.
And because of that, the issue is
this happens. Okay, fine. But the defense will be quick enough to pick these loopholes. Right. Next, Mr. Defense Counsel.
PW6 statement is given. We come to page number 298.
298, please.
299.
299. Next page. Yes, from this.
But please see, Mukul Agnihotri is the PW6.
Right.
So how he says that it is the missing?
Your Honor, but also see the question, is there your signature on post-mortem report? And this is what they have shifted. Now the post-mortem report has become the medical examination report. So it is PW6.
So that means the prosecutor was not careful enough to get it exhibited properly.
No, Your Honor, we were told that the court masters will mark the exhibits, and hence the whole error has occurred.
The court master never mark it. It is the responsibility of the prosecution and the judge. Chalo, anyway, next. But defense has been quick enough to point out this loophole. Yeah, next, defense counsel.
Yes, sir. I'm just all others exhibited documents, my lord.
I got your point. Documents have not been properly exhibited. You said it in the opening arguments.
Yes, sir.
Bring something new, or we should end it.
Sir, the document which is the Mr. PP has referred it to, they are also not exhibited.
Got it.
Mr. PP was saying about the hard disk. It is not exhibited. It is not on record.
I put a question to him. You remember? I had asked this question. Correct.
Yes, sir.
The hard disk should have been exhibited. Who proved the hard disk? It is not there. It is only placed on record along with that forensic report analysis. That's it?
Yes, sir. That's it.
Right. Now whom I have to deal with from the college?
Your Honor, I'll like to rebut the...
Rejoin, right. Rejoin it.
Yeah.
Tell me.
So, Your Honor, answering him beginning with the minor discrepancy of floor in the statement of the eyewitness, Your Honor, that he did not remember the his statement correctly. I would refer to the case of 𝐲𝐴 𝐸𝐵 versus State of Maharashtra.
Right. Have you mentioned the synopsis?
Yes, Your Honor.
Which one? At page?
I have also submitted a compendium of cases.
I have it. That's what I'm asking. Dayaram versus?
𝐲𝐴 𝐸𝐵.
Jayaram. Okay. On page, which page of your synopsis?
Just a second, Your Honor. I'll refer to the case law itself.
No, I'm seeing a synopsis. 𝐲𝐴 𝐸𝐵, correct. 1991 supplementary 2 SCC 677. Conviction based on several testimony eyewitness, minor discrepancy, not fatal, right? In this appeal, okay, fine, got it. Minor discrepancies, correct.
Yes, Your Honor.
Next.
Your Honor.
Every case has...
You will have your turn, Mr. Defense Counsel. Let him clarify. I'll come back to you again. Don't worry. Yeah.
Now, Your Honor, I would also like to lay down the emphasis on page 292 about the court question.
Right.
Where the court has asked the question to Ms. Suman Singh, can you identify the accused person? The answer was yes. Witness has clearly identified the accused in front of the judges.
No, I told them identity is not in dispute. I agree. I accept. Yes. Next.
Now, about the missing report of Shubham Kotak, I think the court is not dealing with that. Or if you want a clarification.
Yeah, tell me.
About the, Your Honor, if you refer to the 164 statement of the victim,
Manu
it
Sharma.
clearly says, Suman
Singh, correct. Sorry, I'm sorry.
So she has clearly told that the wife of the deceased, that is wife of Shubham Kotak, has already died, and the kid, like Shubham Kotak's daughter, is in boarding school. Because of that, maybe the FIR for missing is not registered. Now talking about the cause of death, where it was also brought to the knowledge of the court that the bullet was not found in the post-mortem, Your Honor, I would like to bring the notice of the court, bring this to light of this court that, Your Honor, powder tattooing was found.
Yes.
And the gun is a shotgun, not it is not a pistol or something that the bullets inserts the victim. It is a shotgun and it has small pellets, Your Honor.
Right.
These pellets.
So any pellets were recovered?
Your Honor, the powder tattooing is because of that only.
That I understand. It's a gunshot injury. Powder tattooing, I told the defense counsel, powder tattooing itself proves that it's a gunshot injury. It's a firearm injury. Right.
Yes, Your Honor. Yes, Your Honor.
Next.
Now the khaka of gun, Your Honor, I think the photograph of gun is already...
That is not required. I accept it.
The khaka is not
required.
Now the question regarding the bleeding part, that the tongue was bleeding and she was absolutely fine. So it should be brought to the knowledge of this court, Your Honor, that being absolutely fine and being fine for giving a dying declaration are two different things.
No. See, that is, he may be right at this point, but I am with you only for the reason. That this could have been explained only by the medical expert, the doctor examined.
Yes, Your
He should have been cross-examined. Neither me, nor you, nor the defense counsel are experts on medical lines. So since they have not cross-examined the doctor on this part, that defense will go. Next.
Moreover, Your Honor, regarding the potency test of the accused.
It's there.
Now, it is already there. And moreover, Your Honor, now the medical examination of the accused deals with certain other things. And the forensics deals with certain other things. So forensic deals with that what all things were found, all the things were seized. And
so what do you want to say? What do you want to say? He says the potency examination was not done.
But the opinion report says that that he was
correct. I got it. So why are you clarifying? What do you want to do? That's what I'm asking.
No. I'm just clarifying that if Your Honor may have some doubt in mind regarding that.
No, I don't have any doubt. Next.
Now, regarding the ownership of the car, Your Honor, it is not a case of theft or robbery that we must deal into that, Your Honor, that whether it was registered under whose name or not. Here, what we should focus upon is that the same car was seen in the CCTV footage, and also, Your Honor, acid bottle was recovered from the car.
It may belong to anyone, but okay, fine.
That is part of the disclosure statement. That is part of the pointing out memo as well.
Correct.
And the acid was sent for FSL.
And that matched
the
it.
Acid matched with the acid present on the clothes of the victim and the body of the victim.
And the body of the victim. You are right.
That is important, Your Honor, to bring the offense under 326A.
Correct.
Now, dealing with Mr. Manavendra, that whether he was a forensic expert, whether he was a fingerprint expert or a ballistic expert, Your Honor. If you refer to the cross-examination, he admitted that he is not a ballistic expert. He admitted that he cannot. He admitted that he is not a fingerprint expert. So there is no doubt. Now we are relying on the fingerprint expert's testimony. That is very clear that all the three fingerprints matched on the gun and 2 fingerprints matched on the rod. And there is no doubt regarding that. Neither the counsel has tried to evade the dependency on the...
No. He's saying I'm not a fingerprint expert, but then how can he comment on fingerprints?
Your Honor, because now the FSL...
He is going to the extent of saying that fingerprints of both the hands are same. Then he should have said, I am not a finger expert, I can't answer this question.
FSL is a body which has various wings. It has wings like ballistic, it has wings like fingerprint. Now, that is conjointly they publish the report.
Insofar as ballistic report is concerned, his testimony is reliable. But he had no business of giving any expert opinion on fingerprint. And the court should not have asked him. Court should have asked only about one question, that whether you are a fingerprint expert or ballistic expert. That's it. Now going ahead.
And he said that he is a ballistic expert.
Yes. Correct.
So,
so defense counsel say the fingerprints have not been proved.
Your Honor, but the fingerprints were collected, sent for FSL. The opinion report is clear.
You want to say under 293 that report is admissible?
Yes.
Correct.
Report is admissible, Your Honor. Moreover, report is exhibited also. The report is on record, Your Honor.
Correct. He has a serious question mark on the mode of exhibition.
Pardon, Your Honor?
What do you say? The mode of exhibition. The author was not produced so many documents. See, 293 expert report, no problem. Even the prosecutor can present it. It has to be exhibited. But other exhibits, the author has not been examined, and the author has not stated that these are my signatures, my thumb impressions, and all that. This is a technical point which he has raised, and it's a very vital, very important and vital point.
Now, talking about the thumb impression, Your Honor, I would request you to refer to the statement of Ms. Suman Singh, page 292 of the LCR.
Read it, the relevant portion.
Did you give statement to police after the incident? Yes. Whether the statement recorded by the magistrate? Yes. Did you sign the document which were written by hand in the court? I don't remember. Now, which thumb impression have been given on the statement? I can't recall which one is that.
Then
this is implicit, Your Honor, that thumb impression was there.
No. Thumb impression was there. She should have identified. Yeah, this is my thumb impression.
She has identified because of that only. It is marked as.
No, where has she identified? She has no. See, try and understand rules of evidence, which is very clear. The author has to say that yes, these are my thumb impressions. I identify them. I had put my thumb impression. Then it will be marked, circled, and then an exhibit will be given to the document. So anyway, since this is a mock trial, I'll give it to you. Next.
Your Honor, now talking about the CDR of the gardener, I think that is not relevant when we talk about the CDR of the gardener, because
it is not required. Not required. Yeah. Don't argue on this. Got it.
Talking about the coordinates of the tower, nobody.
In fact, it was for the defense. It was for the defense to show that he was not present there, and for that purpose, they could have produced a CDR.
Yes, Your Honor.
Of eyewitness, they did not.
Even if we talk about the coordinates of the tower, Your Honor, nobody can tell the location perfectly.
Exact location cannot be told.
It is how they manage it through the towers. That what is the location now.
Got it. Next.
Now, Your Honor, in the case of Baljeet Kumar versus State of NCT of Delhi, page 57 of the compendium submitted, and it is there in the synopsis as well, that acid found on the clothes and conviction was held. Here, the acid is found on the clothes. If you see the FSL report, acid was present on the clothes, Your Honor.
Correct.
Now, talking about Mukesh Kumar versus State, page 70 of the compendium submitted. Injuries corroborated with the statement of victim and medical report. These are circumstantial evidences, Your Honor. And that is established. The corroboration is established.
See, once you have a case of eyewitness, then circumstantial evidence cannot be pleaded. If you have a circumstantial evidence, then eyewitness cannot be pleaded. So you have an eyewitness, then why are you going on circumstantial evidence? Next.
Just an addition to the arguments, Your Honor.
Okay.
Rajendra Prahlad Rao versus State of Maharashtra. The presence of white marks clearly shows the signs of struggle, Your Honor.
Okay, white marks. Yes. Correct. Got it.
And moreover, talking about the point what my learned friend said, that marks of struggle can be because of sexual intercourse after the incident and before the arrest. So, Your Honor, white marks are not on the private parts. Here, the white marks were found even on the private parts.
Correct.
So, we can rule out that possibility.
Correct, but okay, fine. Right. Next. That's it?
No, Your Honor. Now, I would refer to the judgment of Jarnail Singh versus State, Your Honor. Additionally, in a state where it was laid down that additionally in a statement number 164, the prosecutrix has asserted that in the first instance, after having caught hold of her, the accused had made her inhale something from cloth. Now, this is totally like relevancy of 164. If 164 is proved, Your Honor, that can form the sole basis of conviction. And here 164 is there on record, Your Honor.
Correct. Next.
Your Honor, also I would like to bring to the notice of this court that evidence should not be counted but rather weighed. And here by weighing the evidence, the testimony
quality of evidence, not quantity of evidence.
Not the quantity of evidence.
I told the defense counsel.
Right. Yes, Your Honor. Moreover, Your Honor, I would also say that all the ingredients of the offenses are met in the instant case, and hence they should be liable for this crime of rape with murder, attempt to murder, 364, and acid attack, Your Honor.
Right?
Yes, Your Honor.
Right. Now what I have to do? Somebody from the college will tell me.
Sir, I have some also other points to argue.
Okay. So it has to end somewhere.
Sir.
Now you will argue, then he'll come back.
No, sir. I'm just putting end now.
2 minutes.
Sir, thank you, sir.
Right.
So just as I was coming by point, as Mr. PP has said that it is not a theft case. But they recovered the acid bottle from that car. So it has to be asked the question ki whose car is, and the document is not exhibited also. So it is not also on record. And sir, the 164 statement that is Mr. PP saying that it is on record, I completely deny it. I do not, in my view, it is not on record.
Why?
Because it is not exhibited by...
It is not been exhibited by the author, huh?
Yes, sir. Neither from the scriber, neither who can identify.
Right. Next.
Sir, again, as he said that the shotgun do not have that bullet inside of that barrel.
Barrel.
It has something, but that didn't brought up. The police didn't recovered it from that crime scene.
Okay.
And sir, the bite marks which Mr. PP is pointing out, the bite marks is maybe the outcomes of the active sexual life.
Sexual life?
We do not have the bite marks matching report also, sir. That these bite marks are of the victims.
That is a point. Correct.
We do not have that also, and if we are having that, it is not on record.
Correct.
So, sir, it is my point. I'm not denying that crime is not committed. I'm saying that crime is committed, but
my clients are not involved.
The prosecution is completely framing the case against my client.
Yes, your clients have been falsely implicated. They have been unnecessarily implicated in this case. They are absolutely innocent. They should be acquitted, right?
And sir, it is the outcome of the police mistakes. Police is not doing their investigation properly.
And your clients are suffering.
Yes, sir.
Correct. Now it's okay. Over.
Yes, sir.
Yes. Now somebody will guide me what I have to do, except for this.
Yes, sir. Sir, please give you a comment or feedback for the participants for their performance.
Right. First of all, the most important part was the addressing to the court. For the prosecutor, I have a word of caution. The word is Your Honor, not Your Honors. Secondly, when you are referring to each other in the court as lawyers, you say the learned prosecutor, the learned defense counsel. We don't say Mr. Prosecutor. That is fine. But in our country, there is a process of addressing each other as learned friend, learned prosecutor, learned defense counsel. Next, I don't know whether these youngsters should be given the blame of this, because in some way the defense counsel was right that documents have not been properly exhibited. The documents have to be exhibited. It is a cardinal principle of law that the documents have to be exhibited by the author of the document. Like suppose 164 statement is there. The victim can prove the statement. Who has given that statement? In the court she comes, she says this is my signature, or the magistrate has to come. A mandatory requirement has been there in some various cases that the magistrate who has recorded the statement should appear in the court and prove that document. Because 164 is a very important statement. Next, the discrepancy in those statements, like the ballistic expert, he's saying, I'm not a fingerprint expert, and still he's commenting on fingerprints. So these procedural flaws are there. Otherwise, the case has been well proved. But defense counsel, I must give this compliment to him. He has come well prepared with the law on this point, that the document has to be proved by the author. And in the eyes of law, the documents have not been proved. But since this is a mock trial, I'll consider this, that because of paucity of time or because the simplicity of the procedure, the exhibits were already marked. But for the purpose of training these youngsters, the procedure of exhibiting the document should also be well laid down, so that they learn the procedure, because someday they have to step out and then go to the courts. Some will be prosecutors, some will be defense counsel. So this is a cardinal principle of law, which this youngster on the defense side has proved, and he has really hung on that issue very well. Next is, see, whenever the final arguments have to be done, please keep in mind, both the sides should keep in mind that they should be interesting for the judge. You just don't have to narrate the facts. Facts, the judge always sees. Facts are on record. The presentation should be so nice that it should attract the interest of the judge. You should narrate it as a story. You must have a little bit of glamour attached to your language, little bit of humor attached to your language. You should be able to convince the judge that he should not get bored, because see, the judge is hearing similar cases whole day long, month after month, year after year. Every case is more or less similar. So here comes the quality of and the style and the court craft of the lawyer who is addressing the arguments. He should make it so interesting that the judge should be glued in his arguments. You should not be found scrambling for papers and all that. You should paraphrase everything well in advance. The argument should be well prepared, point-wise written, a summary of documents, summary of testimonies, everything should be. You have given me everything, but that was not followed in the arguments, neither by the prosecutor nor by the defense. So you should not, the argument which could be concluded in half an hour took 1.5 hours. You have to be precise and pinpointed, because you must understand, in India, courts are overburdened. Judges don't have so much of time. As much they may want, but still they can't give you the time. So the brevity is the best thing in the Indian courts today. You must be able to put across your point in minimum time and with minimum words. And for this reason, your homework should be very good. Just make a summary of your prosecution case, what evidence I have led, what documents I have proved, who has proved the documents. And this is the, after you have read the exhibit, then you say how I have been able to prove the circumstances and the facts leading to the guilt of the accused. Similarly, the defense. So these are the points on which the prosecution is relying. This is my point by rebuttal to them. And this is the supporting law on this point. Hence, my client deserves a benefit of doubt or a clean acquittal. That's it. Otherwise, yes, youngsters have worked hard. They knew every paper which was on the file. They knew everything which was on the file. And they were very clear about the case. Only the presentation was a bit, maybe I'll give them a benefit of being young and newcomers. So that they can improve, still have time to get into active practice. And once you spruce up, it's like tuning up, you know, the sprucing up, the flab, the fat around your argument should be cut down. Make it slick and taut, T-A-U-T, so that it becomes interesting and you are able to say, see, I'm telling you, gone are the days when those lengthy arguments days together used to go in the courts. Now, believe me, I've been a prosecutor for 6 years till 2017. You can't believe it. Judges have been hearing and deciding at least 6 to 7 appeals a day because they come well prepared. They read all the files in their chambers. So you don't get so much of time. They only ask for sterling points and those summaries. So please try and understand. Virtually today, half day of a working day has been consumed in today's arguments. It went over 2.5 hours. The court hours are from 10:30 to 4:30, 1 hour of lunch. Now, how much time you have consumed? If the judge has to spend so much time on one case or the other case, backlog will be there. So please try and understand, be brief, be to the point, and hit hard and make it interesting for the judge. That's it. Otherwise, the rest all is fine. Anything they want to ask, you want to ask, you please ask.
Thank you, sir. So means a lot.
Yeah. Both did well. I'll be grading you. No problem.
Thank you, sir.
Thank you so much, sir. First of all, thank you for accepting our invitation to judge this round online.
You are most welcome.
It was very difficult for us to conduct the round, but because of your help, we could successfully conduct.
No, I understand. I understand. For me also, this is something.
Thank you for giving your valuable feedback and opinion.
Right.
That will definitely help them, though not today, but of course.
Yes. It's an ongoing process. You always stand to learn. That's why we say it's practice. Doctors and lawyers always say, "Aapki practice kaisi chal rahi hai?" We practice all throughout our life. So nobody can be perfect in these two fields. You stand to learn every day. Never feel that I'm completely educated in my field. No. The day you feel that I know everything, your downfall starts. Always be a student, never be a tutor in this field. You learn and you will excel. Yeah.
Right, sir. So thank you so much, sir. With your permission, sir,
yeah.
I would like to give in advance an invitation that whenever the things will become normal, I would like to have you in our campus and I would like to make you interact.
I know. Subject to my availability, I'll certainly be available.
Surely, sir. Surely.
Thank you. Now I just wanted to ask, I have to grade this and then scan it and send it to you. Right? These score sheets.
Yes, sir. Yes, sir.
Right.
Yes, sir.
So I'll scan this and send it across to Shubham. That's right?
Yes, sir.
In next 10 minutes. Okay.
Yes. Okay.
Thank you.
Thank you, sir.
Welcome. So nice of you. Right. Can I leave?
Yes, sir.
Okay.